June 27th.
I told them not to worry, it was still on time.
I have a couple of things to do outside. About 8:30 it is.
Yes, exactly 8:30.
Well, there we are.
Getting started. All right.
Good morning. My name is Ed David, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, or whatever, to ensure that they are silenced now. We have additional agendas, including the consent agenda available in the back of the room. Consent agenda is a list of cases in which no written arguments were made to the commission in the allotted time, and so the commission will vote on those cases directly, and they will not be considered further. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. Commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. Time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one, relevant factual errors, two, relevant omissions from the report of facts submitted during the investigation, or three, relevant issues and questions concerning interpretation of law. Commission allows parties who do not disagree with the investigators' report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions. I'll ask that you introduce yourself as you come to the podium or appear online. So we will start with the business meeting. First item is adoption of the agenda.
Before you move on that, we have had a request to withdraw the first case on the hearing agenda for today, Norellis versus Procter and Gamble. I'm going to recommend that you allow the withdrawal. They have reached a settlement. I'm inclined to let that go forward. So we would change the hearing agenda to remove E23-0289 and keep everything else.
I'll move that we approve the request to withdraw for E23-0289.
Second.
Just a question, Kim.
No, so we got the email on Friday. I didn't see it until this morning. What I would say about this is we also don't have a signed withdrawal form yet. If we don't get one before the agenda for the December meeting is published, I will let the parties know that we need it by then. Otherwise, we're going to put it back on the hearing agenda for December.
Okay, so the motion includes that stipulation.
Second.
Any further discussion? Thanks, Nick. Our remote participation policy requires that the commissioners indicate their vote both verbally and visually.
Yes.
So please raise your hand and also voice your vote. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
All right, so now with that amendment, we can move to adopt the agenda.
And is there a motion for adoption of the agenda and consent agenda?
Commissioners, if I may, my apologies. This is Alicia Hamilton Schneider. I represent Procter and Gamble and the Tambrands entity in the Norellis versus P&G matter, and I just want to make sure that I heard you correctly. That for now, this will be removed from the agenda pending opposing counsel's submission of the withdrawal.
Yes.
Okay. Thank you so much.
Okay, so I have a move. Do I have a second for adoption of the agenda?
Second.
Moved and seconded. Any discussion? Seeing none, if you vote yes, you are in favor of adopting the agenda. Commissioner David,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders. Yes. Minutes from September's meeting. Motion to adopt them.
So moved.
Moved and seconded. Any discussion? Seeing none, if you vote yes, you are in favor. Commissioner David,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas,
Yes.
Commissioner Sanders. Yes. I don't know why it feels like forever since we had one of these meetings, and I'm trying to remember what to do all over again. I know we had one last month. I was here. I don't know. All right, so director's report. We have no changes to personnel since September. For conciliation, we have 2 cases in active conciliation and 1 case that has failed. The 2 cases that are in active conciliation will likely fail, but their 90-day deadline is not until next month, so we will send out those letters on November, well, whatever the next business day after November 23rd is. Unless they change their minds and we can get conciliation held before that. But I don't have any agreements for you to approve, so that is easy.
Litigation.
Yes, and for investigations, we had 26 new cases filed in September with a total of 36 new respondents. 15 administrative dismissals, 8 right to sue requests, 6 withdrawals with benefits, 1 while it was in investigation, and 3 through the MHRC's mediation program, and 2 private settlements for a total of $259,000. No withdrawals without benefits this time. As Commissioner David said, we'll do litigation in executive session.
When you say 2 complainants, that is 2 complainants and not 2 third-party nonprofits or?
Yeah, that is what the complainants got, and it, you know, sometimes it breaks down into a certain amount, goes to attorney's fees, or we generally don't know
You have an opinion on those statistics for other years?
that. Not off the top of my head,
No.
no. The numbers vary pretty wildly month to month. I would say our mediators are pretty good at helping parties come to I think an appropriate settlement, but depending on the case, obviously that's.
Yeah.
Some of them settled for 5,000. We had one recently that settled for like 150,000.
Just a quick question on the status of the reasonable grounds cases report. You note that Libby versus Fletcher's on the pier was unsuccessful, but then in the asterisk on the bottom indicates it was successful.
Oh, yeah, if I
Yeah.
would scroll down, I would have seen that. So usually what that means is that we didn't have a settlement agreement by the 90-day date. So we have 90 days after the commission votes on a case to complete conciliation and get a signed agreement. If the parties are engaged in settlement discussions and it looks like it's going to be successful, we still have to send the failed letter on that 90th day or 91st day, but we sort of keep it open here so we can get, and that one was, there was some logistical challenges with that. Yeah.
Yes, I recall.
Yes. Yeah. New business. We are still, obviously in a federal government shutdown. We have not therefore been paid for either our HUD contract or our EDOT contract since the vouchering processes for both of those happened in October. And the government has been shut down for the entire month of October. We're fine for like a year without those. So hopefully the government will reopen and we'll get paid before
EEOC and what else?
HUD.
But.
Yeah.
Are those quarterly or yearly? Or?
Yearly. Yeah.
So this was a yearly payment?
Yes.
So we've got another year to go on the last one.
Well, I can't remember if this had come out already by our last meeting. there has been new guidance from HUD that says that if your agency enforces a law that protects more classes than are covered under the Federal Fair Housing Act, so the Federal Fair Housing Act covers 7. If your agency enforces a law that protects on more than those 7 bases, you may lose your substantial equivalency and thus your contract. They specifically list sexual orientation, gender identity, and source of income, all of which we cover. So it seems not unlikely that we will lose the HUD contract for the year going forward. It's also unclear. So the Fair Housing Enforcement Office, which is part of HUD that runs all of the contracts that we all do, in addition to all of the cases that HUD investigates. Their staff were among those who were laid off. They all got reduction in force notices a couple of weeks ago. I think they are, at least some of them are party to the injunction that was issued in California, but it's unclear what the status of that is going to be. And it's also unclear how many, if any of them, will be reinstated. I guess that's all sort of depending on the court case at this point. Part of that means that there will be basically no federal fair housing enforcement. So we will be getting more cases because some people file directly with HUD instead of filing with us. And part of that means that if there is nobody working in that office, there is nobody to process a voucher. So we would not get paid for last year's contract either. That would be more of a problem than losing the contract for the year going.
Would it be delayed, or are we contemplating that payment will not come?
We're contemplating that payment will not come without, I would imagine, a lawsuit. The money, as I understand it, those funds have been obligated by Congress. So we have something to stand on there to say, hey, you said they had to give us this money, like, so you give us the money. But that will be, yeah, it's unclear at this point who, if anybody, will be in the Fair Housing Enforcement Office, and what the status of payment for work that we have already done.
So what's the effective date of not enforcing those other grounds that we enforce? In other words, are we going to bring housing cases on
So we
today in court?
It is not unusual, I think, for the last 3 or 4 administrations, the interpretation of sex to include or not include sexual orientation and gender identity for housing cases has been subject to executive order. So I can't remember if there was an executive order about this in the second Obama term. I think there might have been. And then it got reversed by President Trump's first term, and then it got reinstated by President Biden, and then it got reversed again this past January. We were anticipating that. So we stopped dual filing sexual orientation and gender identity cases in January. The other things like we protect on the basis of receipt of a permanent protection order or source of income. There are a few other categories that we cover that are not covered by the FHA. We had not stopped dual filing those. We would probably not get credit for those cases. They are also not accepting disparate impact cases. It's harder I think it's harder to track that because often it's not part of the complaint or we don't know about it until later on in the investigation. So it's not sort of flagged in their database as a disparate impact case. Although HUD requires a lot more documentation than EEOC does. So we're going to keep investigating those cases through our normal investigative process for all of the protected classes that are listed under the Maine Human Rights Act. Whether or not we get paid for cases whether or not we have a HUD contract, we're going to investigate those cases. If we get a HUD contract, I imagine what we will do is just what we have always done, which is dual file cases that are eligible for dual filing with HUD. In the same way that we don't dual file cases with EEOC that aren't eligible because they don't have enough employees or because it's not an employment case. Yeah. So uncertainty, continues, I will keep you posted as I know more.
Good.
But that's the new business for today.
Which puts us right.
Right on time.
So we will continue with the hearing agenda. First case has been withdrawn. Second case is E230362. Rosemary Pitkin versus Convenient MD. The recommendation is for no reasonable grounds, and therefore we would hear first from plaintiff or counsel.
Attorney Fox?
Good morning. Good morning. Can everyone hear me?
Yes.
Yes. I'd love to reserve 2 minutes if I could.
Okay, whenever you're ready, go ahead.
Okay. Dr. Rosemary Pitkin is an experienced emergency medicine practitioner. She in 2022, she took a job working for the respondent as a lead provider in one of its urgent care clinics. The respondent fired Dr. Pitkin just 2 months after she was hired due to the escalation of her escalating concerns regarding patient safety issues in violation of Maine's Whistleblower Protection Act. Respondent had represented to Dr. Pitkin at her hire that there would be a certain level of minimum staffing that they would provide, but Dr. Pitkin found that this was sorely lacking when she arrived on the ground. Additionally, she found that several staff were underperforming and unreliable. For example, respondent frequently staffed Dr. Pitkin to work shifts with a paramedic instead of an RN, where the paramedic was underqualified and underperforming. Respondent also scheduled her to work with a physician assistant who was a recent graduate and needed a significant amount of assistance, even though he was scheduled to serve as the second provider on shift. Sometimes Dr. Pitkin was scheduled to work with both of these providers at the same time. On top of this, respondent imposed quotas for the number of patients that they were expected to see during a shift per hour. And so without proper staffing, these quotas were too high for the safe delivery of medical services. One example, a shift on November 2nd, 2022, Dr. Pitkin was scheduled to work a 12-hour shift with the brand new physician assistant, no RN, and an underperforming paramedic. They saw 63 patients and transferred 4 critically ill patients to the hospital. One of these patients was a geriatric patient with a significant injury who had waited for several hours after meeting with a medical assistant or the paramedic before Dr. Pitkin could evaluate him. Dr. Pitkin immediately recognized this patient urgently needed trauma-centered care and transferred him to the hospital. Had an RN or a qualified paramedic or an experienced second provider been on staff, these 4 patients, including the geriatric patient, would have been properly triaged and transferred to the hospital much sooner. Dr. Pitkin reported her concerns about staffing and patient safety multiple times to her supervisor. And when the concerns were not addressed, Dr. Pitkin notified her supervisors that she couldn't work shifts that did not at least staff an RN. This would ensure that she was not scheduled to work with the underqualified and underperforming paramedic. One of Dr. Pitkin's supervisors validated her concerns and her insistence that an RN be on shift by texting her that this was not an unreasonable boundary for Dr. Pitkin to set. That is a quote. The text is in the record. When Dr. Pitkin was yet again scheduled for a shift without an RN or a competent paramedic, she called out and she escalated her concerns to a higher level of management who had a clinical background, unlike Dr. Pitkin's other supervisors who I think had perhaps medical assistant training only. Dr. Pitkin emailed the respondent's vice president of medical directors on November 27th, 2022, relaying her concerns about the unsafe staffing practices. And that vice president emailed her back saying she would speak with the director of operations and circle back with Dr. Pitkin with some solutions. The vice president also forwarded Dr. Pitkin's email to Dr. Pitkin's supervisors saying, quote, "I'm concerned that Dr. Pitkin is not properly supervised and we're not applying the safety brakes and levers to assist her as a single provider in the clinics. She raises some concerns about the level of staffing she has with her as well. The very next day, Dr. Pitkin was fired by the regional manager. She was scheduled to work yet another inadequately staffed shift that day and forced to call out a second time for the same reason that her supervisors had validated. The regional manager is the person who terminated her and told Dr. Pitkin that she was being terminated for calling out 3 times during her probationary period. And when Dr. Pitkin tried to explain the patient safety concerns and the email exchange that she'd had with the vice president of medical directors, the regional manager said that she knew all about Dr. Pitkin's email to the vice president of medical directors. Commissioners, there are at least 5 types of evidence supporting whistleblower retaliation in this case. Number 1, temporal proximity. Dr. Pitkin was fired just 1 day after she elevated her concerns to the vice president of medical directors. Number 2, there are comments evidencing retaliatory animus by the regional director who fired her when she said she knew all about her email to the vice president of medical directors. Number 3, there's shifting rationales for terminating her. During the termination call, Dr. Pitkin was told that the reason for the termination was sort of a 3 strikes, you're out. 3 strikes, 3 call outs in 90 days. Respondent's own records, a notice of termination says it call out 3 times within 90 days. But in this investigation, respondent has taken a different position and cited a different reason for termination. They've said that it was because Dr. Pitkin allegedly refused to work when no RN was scheduled. This is inconsistent and it supports pretext in this case. Number 4, different treatment. Dr. Pitkin was differently treated than other employees because in terms of her termination. There's termination data provided in this case from the respondent for how it's treated other employees. And you see many examples of people who've called out far more times than Dr. Pitkin in their early days of employment and were not fired. We see examples of other people who received warnings before being fired. They were not, and Dr. Pitkin didn't receive a written warning. We see evidence of people no call, no show, and were not fired. Dr. Pitkin was fired. So she's the only one in this termination data who was fired for supposedly calling out 3 times during the first 90 days. And finally, number 5, departure from its own policy. This respondent has no 3 strikes, you're out policy. It has an attendance policy that Dr. Pitkin followed. And so this notion that she violated any sort of policy is a red herring because it doesn't say, if you're out 3 times during your first 90 days, you will be terminated. We think there are just more than enough evidence here to support a reasonable grounds finding, and that's what we ask you to do in this case. Thank you.
Commissioner questions for Attorney Fox? Commissioner Douglas and then Commissioner Sanders.
Yes, Attorney Fox, good morning.
Good morning.
Yeah, so it's early Monday morning, but I thought, I'm a little foggy, but I thought I heard you say that there was no policy requiring folks to be terminated if they missed 3 shifts in 90 days. Did I hear that correctly?
You did.
That's my question. Thank you.
Thank you.
So, good morning, Attorney Fox. Commissioner Douglas started the question that I'll follow up on, which is the policy itself, the attendance policy. Does it simply describe the procedures for calling out and omit the remedy for missing 3 shifts during the probationary period? Is that correct, or otherwise, if not, could you just characterize the policy? What does the policy say?
Great question, and I'm going to try to pull to. So it's an attendance and punctuality policy, and it doesn't refer to if you're out 3 times, this is what will happen to you. It doesn't refer to that at all. It talks about needing to, in most circumstances, call at least 2 hours before your shift. It talks about, expectations to be in regular attendance and to be punctual. It talks about certain types of leave being legally protected, and that, you know, employees won't be penalized for legally protected absences. It says the absent an extraordinary circumstance or legal protected reason, absence of 2 consecutive scheduled shifts without a phone call at least 2 hours prior to the head of a scheduled shift, the employee will be considered to have abandoned their position, voluntarily terminating their employment, but that doesn't apply here.
And do you say it doesn't apply because of that calling out quote for a legally protected reason? Is that the argument? Attorney Fox?
Well, there is that argument, but it says absence of 2 consecutive scheduled shifts without a phone call to their practice manager. And so in this case, Dr. Pitkin followed the policy and timely contacted the practice manager and gave the appropriate notice.
Thank you. David.
Attorney Fox, is the facility licensed? What licensing or approval authority does it have to operate?
That may be a question for Respondents Council. I'm not sure.
Well, what I want to ask is what is the legally protected act? What is the violation that you're saying she reported, which is being retaliated against because it's a violation of a
Thank you. Yes.
law or whatever?
Thank you for the question. Yes, so under Maine's Whistleblowers Protection Act, the employee doesn't need to necessarily cite a violation of a regulation. In this case, it's a condition or practice that would put at risk any other individual. So it's a safety concern that she's raising. She's not raising a violation of law, necessarily a violation of a regulation. She's saying, look, the way that you've put me in this position with the staffing that we have and the level of competence of the people I'm working with, I don't think this isn't safe for patients. So it puts at risk the safety of another person. And that is covered as legally protected activity under the Whistleblowers Protection Act.
So that puts her in the position of determining what the staffing should be. And that's what's concerning me. Are they licensed? Are they conforming to some standard? And Dr. Pitkin doesn't like it, and so she wants to control the staffing?
So I think that is respondents' argument that they met the standard of care, and you'll probably hear Respondents Council say, look, they met the standard of care in terms of the types of people they had in the positions. And but what they are not considering is the fact that that they were staffing certain paramedics. So let me just back up. Dr. Pitkin does not believe that RNs and paramedics are equivalent. And that's a disagreement between her and the respondent. But on top of that, there were paramedics who were not competent. And so when you had a situation where she's there with a brand new physician assistant and an incompetent paramedic, not because he's a paramedic, but because of his level of performance, that is an issue that we submit is legally protected when she reports this to the supervisor. So it's not so much that we're saying, look, you need to have this number of people on staff or these types of people on staff. It's that when you combine these types of people and their qualifications and level of performance, it created a safety risk that Dr. Pitkin, as an experienced emergency medical doctor, observed with her own eyes and reasonably believed was an issue. And her supervisor told her in a text that insisting an RN be on staff was not an unreasonable boundary. So I think there's evidence here that it's more than just Dr. Pitkin's personal preference of who be on staff.
Thank you for that, Attorney Fox. And then just so I'm clear, otherwise, and follow up to my colleague's question, it's true, correct, that ultimately it really, from a legal perspective, right, it doesn't matter whether your client was correct in her assessment of the safety concern. What matters is whether or not the employer was motivated, by animus about that report in any capacity, right, as the rationale for the termination. Is that correct?
That's exactly right. And I think, she needs to show that she had a reasonable belief that it was an unsafe practice, but from an objective and a subjective vantage point. But we think that all things considered, that she certainly did. And that in this case, the vice president of medical directors, was at least in the email, validating the concerns she was raising, making a plan to follow up. And the regional director just cut her off at the pass and fired Dr. Pitkin before that could be reviewed or tended to.
Thank you. Other questions for Attorney Fox? Seeing none, you'll have about 2.5 minutes left when we come back to you. Attorney Keneally?
Good morning. Thank you for allowing me to present today. Commissioners, I want to start by saying that Investigator O'Reilly is correct in her decision. Convenient MD would not have terminated Dr. Pitkin had she not refused to work. She refused to work, and her reasoning was that they would not promise to schedule her with an RN. Now, the argument that some paralegal was underperforming is a modification of her original position in this case. The paralegal was not the person always being scheduled with her. And the paralegal in my client's, I'm sorry?
Do you mean paramedic?
I'm sorry, paramedic, excuse me. The paramedic was not someone that was being scheduled with her all the time. So the situation with that paramedic, in my client's opinion, is a good worker, was able to perform the services that paramedic was asked to perform. My client maintains that its staffing policy and practices are industry standard, are legal, and they continue to be the same today. The complainant doesn't cite to any standard, law, regulation, rule that my client was violating. The simple fact is that she didn't agree with my client staffing practices, and she objected to not having an RN with her at all times. And my client doesn't staff RNs on every shift and doesn't have to. There's no licensing requirement for that. And frankly, my client doesn't have the RNs employed in their organization to staff an RN on every shift. So the complainant was not raising a concern that's covered by the whistleblower protection law because she wasn't presenting an actual safety concern to my client. She wasn't alerting my client to an actual safety concern or one that she reasonably believed. She just had a preference to work with nurses, and that disagreement with my client's, her employer's staffing model is not protected by a whistleblower. And I point to the case of Pouchard versus Riverview Psychiatric Center, a Maine Supreme Court case that was decided in 2020 that's right on point, that says that the point of a whistleblower protection claim is to bring to the attention of the employer a safety concern, not your preference on staffing. And the complainant isn't citing to anything that my client actually did that was unsafe or what standard she's holding them to besides her own. And that disagreement is not protected by the whistleblower protection law. I asked the commission too to look in the record at exhibit 8 to our position statement, the probationary period policy. It specifically says that your initial 90 days of employment are on a trial. The 90-day probationary period provides the company an opportunity to observe and evaluate your capacity, which includes your ability to satisfactorily perform the essential functions of your job and to observe and evaluate your work habits and conduct, including attendance and your relationship with coworkers and superiors. During the probationary period, the company may terminate your employment with or without cause and with or without notice. That is the policy under which Dr. Pitkin was terminated for refusing to work within the scheduling model that my client maintains. She didn't like the model. She didn't want to come to work. She told her supervisor that she would not work, so she was terminated. That's the case, plain and simple. My client would have continued to employ Dr. Pitkin had she not refused. And it's also critically important to recognize that she was a lead provider. The clinic cannot operate without a lead provider on duty. So when a lead provider calls out or refuses to come to work, it prevents care to patients. You have to reschedule patients. You have to cancel appointments. You can't open the clinic without a lead provider on duty. Critical role within the organization, and she was refusing to work. So what employer wouldn't terminate someone who was refusing to work? I submit to you that this is not a case about whistleblower protection. This is a case about an employee who wanted to dictate to my client their staffing model. She didn't like their staffing model, didn't agree with it. So my client terminated her for that. It's that simple. It's not a case where my client had any animosity toward her about claiming there was a staffing issue. They were concerned that they didn't have a lead provider to work at their clinics when she was refusing to show up to work. Thank you very much.
David.
You referred to an industry standard. Is there an industry standard? Is it in the record?
There is no industry standard in the record. My client maintains that it staffs like every other national. I take that back. I did put standards into the record. They are in our rebuttal. They're in the record. I just don't have them in front of me right now.
Is there a licensing authority for that level of medical service in the community?
Not 100% familiar with Maine's requirements on licensing, but I know my client adheres to their obligations with each state that they operate in.
You're not saying, are you, that there had to be a particular incident in which some misstep was made because of the lack of training or incompetence of the paramedic as opposed to what an RN would know how to do?
I'm not suggesting that there had to be an accident or an injury to somebody. What I'm saying is that the complainant has to establish that she had a objectively reasonable basis upon which to claim that my client's staffing model was unsafe, and she has not presented a reasonably objective basis for that beyond her own opinion, which my client disagrees with and operates this way in multiple states and has done so for years.
How many states does your plan operate in?
They operate in New Hampshire, Maine, and Massachusetts.
Thank you.
Yes, good morning.
Good morning.
Yeah, so I heard you say she hadn't articulated any active safety concerns. And I'm looking at the report. In the first place, there's this incident on November 2nd, 2022, right, where she says that inadequate triage was provided because the triage was not provided by the nurse. Isn't that, to the extent that was the standard, I'm not saying it is, isn't that one incident sort of close in time to the events giving rise to this case?
Well, if it were an accurate report, perhaps, but that's disputed factual scenario that she's alleging. My client disagrees that person wasn't properly triaged and wasn't properly tended to. Again, it's her opinion about the scenario rather than fact. And again, she has to raise in to my client an objective safety issue, and my client looked into that scenario and determined that it wasn't a safety issue. So it's disputed as to whether or not there was actually that an incident of lack of safety. So I guess my point is that um, she again wasn't terminated because she raised a safety concern. She was terminated because she refused to come to work, and we don't believe she had objectively reasonable grounds upon which to refuse to come to work.
So I guess your comments sort of lead me, can you hear me okay? Because I see.
Yes, I can. Sorry, I just needed to lean in a little bit.
No worries, I'm in sort of a weird place in the room, so your comments sort of lead into what my growing concern is about this case, about the recommended finding, which is the even chance standard at trial. And you say, for example, that her beliefs that things were not operating safely was objectively unreasonable. Here we have a licensed physician that's going to take the stand in trial and say, I believe that these practices were unsafe, and here's why. Right? This is going to go on and on about, paramedics versus licensed nurses and so on. And then we have the business where she's calling out and, nobody's saying, well, you better get your booty to work, otherwise we're going to terminate you. They're saying, oh, you know what, that's not an unreasonable position to take. And then they terminate her. And then the fact finder trial is going to learn that there is no policy that expressly states, I credit your explanation of the policy there where, they could fire her without cause and so on. She didn't show up to work. But the fact finder is also going to hear that there's no express policy indicating that if she didn't show up for work 3 times, she had to be fired, right? And I believe they're also going to hear testimony about other folks that were treated differently, right, from complainant submission. So the even chance standard, I think, is really where I'm thinking right now, and I just wanted to get your thoughts on that, just sort of laying out all of my thinking so far.
Yep. So I have two thoughts on that. One, supervisor meets with Dr. Pitkin to discuss her not showing up for shifts and her refusal to present to work, and tells her you need to come to work, and she refused. And then the supervisor terminates her. There's going to be no evidence of anybody who refused to come to work and was not terminated. Okay, so that's one issue. The second issue, again, is this Pouchard case where the person raises a concern that they have about staffing issues, and the organization was not being alerted to something that they didn't already have knowledge of. My client knows what staffing it requires, right? This was just a difference of opinion on whether or not my client's staffing model is adequate. And that court, the Supreme Court, said that's not a whistleblower case. So I'd ask you to just consider the Pouchard case if you're having concerns about the decision of the investigator. I think the decision of the investigator is spot on. There was no proximate cause. She wasn't terminated because she was complaining about a legitimate safety issue or complaining about my client's staffing model. She was terminated because she absolutely refused to come to work. And my client can't operate that way. If she came to work and still raised issues about safety with management and tried to get things changed, my client would still have employed her. She said, I'm not coming to work. So what are we supposed to do at that point? Is my point.
Thank you.
Thank you.
Commissioner Sanders.
Yeah, good morning. I think we can set the Bouchard case entirely aside because I'm worried that you're mischaracterizing the plain language of the statute here. You've told us several times that you believe that this Whistleblower Protection Act requires some kind of an objective right, standard that in this case, Dr. Patinkin has to objectively believe, right, that, that there's a safety issue afoot, or that the standard is, right, the rest of us have to objectively believe there's a safety issue here. That's not what the statute requires. So the statute requires two things. One, that Attorney Fox's client, in this case, the complainant, act in good faith, and two, that she had a reasonable cause to believe, right? Again, nowhere in the statute is there any objective standard. It's all sort of tethered to the complainant's reasonable cause to believe, acting in good faith, that there was a concern here, right, for patients who are appearing and presenting for an office visit at Convenient MD. And so I just want to clarify that with you and try to better understand where or why are you injecting this objective standard here?
Sure. Happy to. So that there's a couple cases. First, Stewart Door case versus Weber Hospital. It's a 2011 Maine case, and the Bard versus Bath Iron case from 1991. They both cite to reasonable cause. The reasonable cause requirement is met only when the employee presents evidence showing that she had a subjective belief that the dangerous condition or practice existed, and that the belief was objectively reasonable, in that a reasonable person might believe that a dangerous condition existed. So again, I'm not saying she had to cite to a standard or law, but to determine what my client is whether or not my client's practices were objectively reasonable to a reasonable person. One would want to look at staffing in the industry, laws, rules, standards, practices. And she hasn't cited to anything that suggests that my client isn't doing what everyone else in the industry is doing, or any law that they're violating, or any regulation that they're not adhering to. So I'm suggesting that if you had to decide the whistleblower case, which again, because the decision in this case by the investigators that there's no proximate cause, which I agree with, you don't have to decide the whistleblower issue. But if you had to decide the whistleblower issue because it's being raised by complainant, she's not citing to anything objectively reasonable that a reasonable person would rely on besides her own opinion. And I get it, it's her opinion, but that's not the standard that my client has to staff by.
Yeah, I'm going to push back on you a little bit about, your characterization that the safety issue was simply the complainant's opinion. In reading the materials here, I see at least two pieces of evidence that would support the complainant's belief, right, that there was a good faith and reasonable cause to believe there were safety concerns here. So the first one being, isn't it true, if you look at the complainant's rebuttal to the investigator's report, page 8, paragraph 2b, right, this notion of at least one other physician in the corporate structure that the complainant reported to about these patient safety concerns seemingly agreed with her, right? Quote, this other individual says, I am concerned that Dr. Pitkin is not properly supported, and we are not applying the safety brakes and levers to assist her as a single provider in the clinics, right? So that's indicia to me, that's evidence that a reasonable person could come to the same conclusion that she has. And then otherwise, right, there's this example in the record of a patient that the complainant believes wasn't triaged appropriately and therefore was delayed in accessing an appropriate level of care right at a hospital being transported. So, I'm struggling with why aren't those two examples sufficient to demonstrate that the Whistleblower Protection Act here applies and that the complainant is covered by it?
Well, again, she wasn't terminated for her complaints about the whistleblower issue that she's raising, the safety issue that she's raising. She was terminated because she refused to come to work. So that's one thing. But then, secondly, um, the the client would have continued to employ her had she come to work. So I'm struggling with the concept of uh, so relative to the issue of her termination being uh, reasonable. The the Pouchard case points out that the person needs to raise a safety concern that the employer was unaware of and that uh, enlightens them, and then has to be terminated for it. So, to in my client's opinion, its model is safe, and they continue to staff the way they've staffed, and they didn't terminate her because of uh, her voicing a concern about safety. They terminated her because she refused to show up for her shifts. And I just see it as a difference. And so did the investigator. And I believe the investigator's interpretation is correct.
Why isn't the proximity though in the complainant's case, right? Proximity between the protected conduct and the adverse employment action. Here we've got literally 24 hours. Why isn't that indicia of violation of the Whistleblower Protection Act, right? That doesn't get the complainant at least at that even chance of success at a trial.
Because when the supervisor goes to meet with Dr. Pitkin and tries to work out the situation with her and get her to show up to work, she refused to come. And my client can't operate its facilities without a lead provider and would have to reschedule everyone. So it was a situation where you had someone who was not willing to work within the system, and my client terminated her for that. So I think the timing of it was simply a product of she's supposed to work that next day and is already telling the supervisor, I'm not going to show up. The company can't operate like that with employees that are refusing to come to work. So
Remind us if we still have an opportunity to hear back from complainant's attorney and then respondent's attorney again.
Is that termination within the probationary period?
it is, yes.
Thank you.
Attorney Fox, you have 2.5 minutes.
Thank you. Just a couple of things. Respondents counsel kept saying that that Dr. Pitkin was told she needs to come into work and she refused. That is just false. It didn't happen. What happened was she raised the safety concern, set a boundary of, I need at least an RN to be working in order to avoid the incompetent paramedic that she was sometimes assigned. And she was told by one of her supervisors that was not an unreasonable boundary, and that text is in the record. Respondents counsel also is wrong in saying that it's a shift that we're now talking about the paramedic underperforming. On November 21st, this was just a week before she was fired, Dr. Pitkin raised the concern by text that she says, I've worked with some medics at CMD that were not really competent at drawing blood or starting IVs or giving meds or even doing EKGs, and I just can't see 4 patients per hour and teach a new AP1 and give meds. It's 3 separate jobs. And so she's raising that in the context of her saying, I need at least an RN to be on staff with me. And she did that a week before she was fired. Respondents counsel keeps saying she was fired because of she was refusing to work without the RN, but that's not the reason that they gave her. That's not the reason she was told on the termination call, and that's not the reason that was cited in the document, in respondents' own documents regarding this notice of termination. It says she was terminated not because she refused to work with RNs. She was terminated because she called out 3 times in the first 90 days. And as I had mentioned before, that doesn't square up with how they treated all of the other employees who had performance issues. On the Pouchard versus Riverview case, this is a completely different scenario. At Riverview, there were well-known staffing deficits that Riverview was actively working on, that the legislature was working on and aware of, that was all over the media. And so the court found that the plaintiff in that case wasn't bringing up anything new that wasn't already being worked on. So how could they be a whistleblower? This is very different.
That is your time.
Okay.
Commissioner questions for Attorney Fox? Seeing none, we'll go back to Attorney Keneally. You have 4 minutes and 16 seconds.
I don't have any further unless there are questions.
Commissioner questions for Keneally? Okay, seeing none, we've heard from the parties, and next we'll hear from Jane O'Reilly.
Good morning, Commissioners. My name is Jane O'Reilly. I'm lead investigator, and I was the investigator who completed this investigation. I was not the investigator during the investigation. It was conducted by a former investigator, but I have thoroughly reviewed the report and finalized it in this case. I did leave the file on the table because it's very large, but I did look up and can confirm that the policies regarding absences were accurately reflected. There's no specific policy that says any number of absences is grounds for termination. It's simply excessive or, absences that interfere or absences that are not excused. I will point out that this sort of contention that the 2 reasons for termination are not consistent with each other, that, 3 call outs, 3 strikes versus refusal to come to work. 2 of the call outs were because there was no RN on shift. So in terms of this idea that, in terms of my, review of the record and my review of respondents' answers, it seemed consistent. They had this, if it was going to become a pattern, that 2 of her call outs were not for sickness, were not for emergencies. She simply refused to come into work because she didn't feel like it was adequately staffed, and did indicate that she was going to continue that as well. She'll come in if it had the staffing that she requested. If it didn't have the staffing she requested, she was not going to come in. I do think that it's important to go through sort of how I saw the analysis in this report. I think it's been a little bit, neither party has sort of accurately described how I did my analysis in this case. And that's because there's sort of 2 aspects to whistleblower protection. First, my finding was that she engaged in protected activity. There was no dispute in my mind that she had a reasonable belief based on her experience as a medical physician that what she saw was not necessarily up to a standard of care. There's a lot of gray area in terms of, medical negligence, all those things. It wasn't up to me to decide whether or not what she was seeing, or for, I didn't step in to make a medical analysis there. She engaged in protected activity. However, in order to sort of refuse to work, you have to have, you can have a reasonable belief for protected activity. In order to refuse to work, you have to be correct. You can't just have a reasonable belief. You have to be sure that what you are being directed to do, and I actually have the statute because I knew I was going to forget, refuse to carry out a directive to engage in activity that would be a violation of law or rule adopted under the laws of the state, political subdivision of the state, United States, that would expose the employee or any individual to a condition that would result in serious injury or death. So I think the sort of refusal, protected activity, reasonable belief, all of that has gotten a little bit muddled. And I think at one point it was Respondents Counsel who accurately stated what I found in my report, which was that if she had simply continued to report these issues, she had simply said, this is not actually good staffing. Some of these employees don't have the skills I need. I'm drowning because I'm having to do all these other people's work because they're not doing their work, she would not have been terminated. The reason she was terminated was because she said, while these conditions still exist, I'm not going to show up to work. And that was too much of a burden on the respondent who cannot open the clinic. And sometimes they had to use a remote provider, which means that they couldn't get someone physically in the clinic. They had to use someone remote, and that significantly slowed down the amount of patients they could see. So I found in the record that respondent was able to substantiate that it was hard for them that she wouldn't show up for work, and that it was that fact alone that was the reason for her termination. I also want to clear up this issue of the supervisor's comment. So complainant worked in 2 clinics, Portland and Westbrook. In Portland, she had no issues with the staffing. During the conference, she talked about Portland and how Portland often had adequate staffing. There's more people in Portland to staff that clinic. Westbrook had struggled more. And it was the supervisor who oversees Portland that made the comment that it was not in a reasonable boundary. And it was the supervisor who oversees Westbrook that terminated her. So in terms of the director that she sent the email to oversees both. And again, take with that what you will. I just wanted to clear up that sort of, I thought that also was getting a little bit muddled too as to who was giving her what information. She was talking to both supervisors. And she certainly, it is true that there was nothing in the record saying, one more and you're going to be gone, one more and you're going to be gone. But as we've established with many cases here, we're not HR. What I'm looking for in my investigation is to determine whether or not the reason for termination was based on these reports or whether it was based on something else. And I'm happy to answer any questions.
When you say she has to show a violation of a law or a rule, what is that from? Is that
This is all
statute or case law?
It's the WPA. So
Law.
so the Maine Human Rights Act references the WPA. If you engage in protected activity under the WPA, you're protected from retaliation. I'm reading from the WPA statute, the statute that actually lays out what's considered protected activity under the WPA. So A, B, and B are both the sort of reports of what they reasonably believe. And then D is refusal to act on a directive. A different form of protected activity under the WPA.
Thank you.
Commissioner.
Thank you very much. I'm really curious about your footnote 3, right, which gets at this very issue. So it begins, right, quote, in order to succeed on a claim of retaliation for refusing an unsafe directive, in this case, it would be to work. Complainant must establish that the directive, quote, would expose the employee or any individual to a condition that would result in serious injury or death. And then if you move on to the next page, you say complainant did not establish that the respondent's staffing model actually threatened any individual with serious injury or death. And I'm curious about that piece. I guess I'm inclined to defer to the expertise, right? In this case, the complainant is a very experienced physician, has worked in a variety of settings in the emergency room, in urgent care and others. And so to the extent that what she's seeing is, in her opinion, based upon her experience and training and belief, is unsafe, why wouldn't we give her credit for that opinion? And right, couldn't that be a fact to consider in this kind of even chance of success at trial standard?
So an even chance that what she was refusing would result in serious injury or death.
Correct.
So like we're talking about the protected activity again. Okay.
Couldn't we credit her at this stage with, yes, let's assume that that's the case, right? Because she's telling us that that's the case.
You could. It's not what I saw from the record, given the fact that the only incidents she reported didn't result in serious injury or death. None of the patients that she saw, even the ones that she allegedly said were not triaged correctly, resulted in serious injury or death. The fact that respondent even then disputed that, said, and again, I'm not a medical professional, I don't know if triage would have been caught earlier. And also because, yes, complainant is an experienced medical professional, so is everyone else who oversees these clinics. They're overseen by people who have medical expertise. Other lead providers work in these clinics. It's industry standard. She wasn't seeing anything that looked from the record, even the seriousness of what she was reporting, didn't look to me to be anything that was specifically related to what she was refusing to do, right? She was refusing to be there unless RNs were staffed or a particular paramedic. There was a particular paramedic she thought was experienced enough to be there with her, but sort of picking and choosing which staff didn't to me indicate that there was a would-be serious risk to, would-be risk to serious injury or death as a result of not having an RN on staff. Again, yes, that's a decision that someone else reading the record may come to a different conclusion on, but my understanding of sort of understanding the worst of what complainant reported, it still didn't reach that standard.
So it would be helpful in the record, for example, to have further development about, generally speaking, like the population that serves at these clinics, right? We would want data on the acuity, right, of folks who present, the frequency with respect to, transfer to the hospital for further treatment. All those things, for example, would be helpful in trying to understand, the standard that we're talking about. But
Preliminary investigation,
Yes.
Commissioner.
Right.
Just
preliminary
for
investigation.
Certainly, we would want that information in court, but we would not have the time or for it to hear. The footnote, I just want to be clear, is about Part D only with regards to the Whistleblower Protection Act, which is refusing to carry out an act. And there you have to be right, not just have a reasonable belief. And that had nothing to do with the finding with regard to her reports. That was about refusing to go to work.
Right. I think the crux of my analysis is that I have to find that absent her reports, she would have remained employed if I'm going to find on the reports. And I found that it wasn't the reports, it was the refusal to come to work, right? So she could have continued to make the reports. They would have continued to employ her, would have continued to try to work with her, but she made a statement that I'm not going to come to work unless it's an RN. And that was the reason she was doing
Yeah,
Yeah.
so
Commissioner, you all can manage yourselves.
jumping in. So I appreciate your detailed analysis, very helpful. In terms of her having to be right, she's gonna refuse to come. You agree with me, right, that at trial, right, she's gonna present evidence as to whether or not she's right. Respondent's gonna submit contrary evidence, somebody at trial is gonna decide, right? Do you agree with that? Thank you.
Commissioner Dick.
Barbara, are the case citations relevant? Did you find them appropriately cited or? Do we have to go read them and take another hour?
So, I mean, the case citations are what case citations are. I mean, what you need to do is decide whether there are reasonable grounds based on what's here. And I will say, and you guys are all focused on the right issue. I mean, the question is even chance standard, and I think Jay would say it's not necessarily that easy a case on that, so. We're gonna need a break so I can refresh on all of those cases. On them, especially in public.
All right. I've heard from the parties and the investigator. Now, for a motion. And report in from the case, I don't know.
I
what we
do.
recommended.
There's one
One recommended finding.
One
Okay.
recommended finding, I'll make a motion that there are no reasonable grounds to believe that respondent retaliated against complainant under WPA or MS.
Got you. Commissioner Walker, was that a second? Okay. Moved and seconded. Discussion?
The case became a lot closer in the presentations, but at the bottom analysis, I am persuaded that she's trying to determine the policy, that the correct approach would have been to stay there and continue to make those arguments to supervisors, and we ought to be doing it a different way or not. But to say, I'm not coming to work unless you do it my way, within the probationary period means it's not official.
So I'm troubled by the failure to come to work as well. I hear that. I think that makes this a closer case. I think if she continued to come to work and was experiencing adverse employment actions after continuing to work, the finding probably are different. I guess where I have pause here is, you know, all of the questions about whether or not this was a safety issue, whether or not she was right. And I'm envisioning the testimony unfolding at trial where we have a credible licensed physician saying that these are serious safety concerns. And I wasn't coming to work because I was afraid somebody was going to be seriously hurt. I was afraid somebody was not going to get the treatment that they needed, right? And the respondent putting on, you know, contrary evidence on all these questions, whether or not she was right. You know, it's interesting, respondent's counsel said, well, it's just her opinion. This whole trial is going to turn on opinion testimony, in my opinion, right? So I feel like the even chance standard is in play here, and I have a hard time finding there are no reasonable grounds that this case should proceed.
Discussion? Seeing none. If you vote yes, you are in favor of adopting the no reasonable grounds finding. Commissioner Davis.
Yes.
Commissioner Douglas.
No.
Commissioner Walker.
Yes.
Commissioner Sanders.
No.
As it is a tie, it reverts to the investigator's report. So the findings are no reasonable grounds. We will send a letter to the parties confirming the results of the hearing. Thank you, everyone, for your participation. We take 5.
Sure. We'll be in recess for 5 minutes.
Thank you.
My husband said.
Yeah, let's call the session to order, please, and we will consider the third case on the agenda, which is Monica Giordano versus Roman Catholic Bishop. The recommended finding is for no reasonable grounds on all three counts. Therefore, we will hear from complainant first in the presentations.
How about a minute? When you're ready, go ahead. Thank you. Good morning, commissioners. I'm Kristen Aiello, and I represent Reverend Monica Giordano, who's sitting right over here. For nearly 20 years, Ms. Giordano served the Diocese of Portland as administrative assistant at St. Joseph's Parish in Ellsworth. She was 72 years old at her termination, loyal, capable, and deeply faithful. We're here because the investigator's finding of no reasonable grounds does not square with the evidence or with the law. The record shows a pattern of age-based hostile work environment, harassment, a failure to act, and retaliation that ended a 20-year career. Beginning in early 2023, Ms. Giordano's supervisor, the parish priest, began calling her old, too old for the job, unable to remember things because of her age. He mocked her, holding up boxes of adult diapers and saying, "You know what these are for, Monica." Then one day, while they worked on the Easter bulletin, he became angry, slapped papers in his hand, marched across the room, threw papers deliberately at her face at close range, striking her eyes and cheeks. And during this time, he told her, "You're getting too old for this job." And this was an admission at an IRC from the priest that he said that he was just getting too old during that interaction. She was stunned, frightened, and humiliated. The investigator correctly found that this caused a hostile work environment, but wrongly concluded the diocese was not liable for two reasons. First, the diocese did not exercise reasonable care to prevent and appropriately correct promptly any harassing behavior. Second, in any event, because the harassment resulted in tangible employment action under Maine law, the diocese is automatically liable. But I want to talk for a minute about what the diocese did after Ms. Giordano complained. She reported the harassment and assault on April 11th, 2023. The diocese took the complaint in writing, the HR manager, but did nothing. Priest harassed her again one day, telling her one more time, Monica, and doing the cutthroat thing, and you're fired. My client reported to HR again. For 24 days, the diocese did nothing. There was no investigation. There was no follow-up. There were no questions for anybody. But on the 25th day, the Monsignor, and I think also referred to as Bishop, made a single phone call to priest and told him to, basically in essence, told him to stay away from Ms. Giordano, even though assisting him and assisting the priest of the parish for the past 20 years was her job. Thereafter, she was effectively isolated, made a pariah in the office. She said to HR, she wrote to HR, "Priest keeps making changes to the priest schedule and somehow forgets to keep me informed. I am bypassed by his communications." Stay away from Monica is not a remedy. An employer may not satisfy its duty of reasonable care by imposing a remedy that isolates or marginalizes the complainant rather than addressing the source of harassment. A response that effectively punishes the victim can itself support a finding of continued hostile environment or retaliation. Freezing my client out and giving her the silent treatment is tantamount to a failure to act and provide appropriate action. Second, the employer, the diocese, took tangible action against my client in a number of ways. First, the order to stay away, ordering their supervisor to stay away from her, effectively isolating her in the office, depriving of her ability to work was a tangible employment action, and also issuing the written warning to her that says the accusations and rumors must stop. Now, this was under Maine law. I'm happy to answer questions about this, but there's a Commission Council memorandum from 2010 that involves a similar situation where Commission Council concluded in his memo based on King versus Bangor Federal Credit Union that a written warning received, which threatened a complainant with termination if she didn't improve her attendance, constitutes actionable action. actionable unlawful discrimination. Interference and intimidation is prohibited under the Maine Human Rights Act. My client was a qualified, longstanding employee who was exercising her right as a 72-year-old employee in the workplace to exist without being harassed, demeaned, and threatened because of her age. Here, priest yelled at her, threw papers in her face. He taunted her, "You're old, you can't remember anything." He threatened her, "That day is coming, Monica, given your age." If this is an intimidation, coercion, interference in an older person's right to exist in the workplace, I don't know what is. There is an even chance here as well. Termination and pretext for age discrimination. Again, there's reasonable grounds to believe discrimination occurred here. After nearly 20 years of loyal service, she was suddenly labeled combative and accused of spreading rumors. Those rumors were her truthful reports of harassment and abuse. She was also accused of taking a camera, but the Ellsworth police report states they don't know if she took it or not, they just want it back. So the diocese didn't know who took it, yet they used that as a reason to fire her. When an employer statement is false, that's pretext. The priest admitted at the IRC, maybe you're getting too old for this job. That's direct evidence of age discrimination. Ms. Giordano was the oldest employee. A new office manager, 20 years younger, started assuming her duties. Others received raises. She did not. Exclusion, reassignment of tasks, denial of raises, termination. This is a textbook pattern of age discrimination. And finally, my client engaged in protected activity under the Whistleblowers Protection Act when she reported that she was assaulted with papers in the face, for example, and harassed. There are several escalating acts of retaliation that followed. First, the diocese ordered her supervisor not to speak with her. Again, as I talked about, cutting her off from her duties. She returned from vacation to find her desk cleared, her computer disconnected, and her files gone. She complained about that. Then, as I've discussed, escalating acts of retaliation included the retaliatory disciplinary meeting where she was threatened with termination if she continues making accusations and rumors. Each of these actions would deter any reasonable person from reporting misconduct under Burlington Northern. Retaliation isn't limited to firing or demoting someone. An action that would discourage a reasonable employee from complaining is unlawful. And the close timing shows a direct causal link. This was retaliation, not a coincidence. Commissioners, there's no misunderstanding here. This is a story of a 72-year-old employee who gave nearly 2 decades to the parish, endured humiliation at the end of her employment after a positive work experience for nearly 20 years. She reported it in good faith, and she was cast aside for doing the right thing. We respectfully ask this commission to reject the investigators' no reasonable grounds and finding and determine that there are reasonable grounds to believe the diocese subjected my client to age-based harassment and hostile work environment, interference and intimidation, violation of the Maine Whistleblowers Protection Act, and termination. And I'm happy to answer any questions.
Tell me about the discrimination in terms of raises. What's in the record about
Yes.
employee raises?
In the record, my client stated in her sworn charge of discrimination, she indicated she heard the bookkeeper ask about raises for everyone except her. She didn't ever get a raise, and that's the extent of it.
And where's the camera? Do we know?
No, absolutely
It
not.
drives me crazy when I read, completely different things about that.
I know, I agree. But from the very start, my client was absolutely clear that she did not, the only camera she took was the one that she was told to take out when she returned to the office, and she unplugged the cameras and handed them to the priest.
And the third thing, and I stumble on this a lot. If I'm finding the age discrimination in the environment, why isn't that enough? In other words, where's the retaliation? It's those things that are unlawful discrimination. What's the retaliation for complaining about?
Well, things really ratcheted up after she wrote the email to the HR person in April when she said I was harassed and the papers were thrown in my face. After that, it didn't stop. Then when the priest was talked to 25 days later, then she ended up losing sort of her footing, her place in the office, her status, her ability to move forward. Because she was isolated.
And she shows up and they've shut down her computer, that's being fired, that's the employment action. And if we find that that's okay, so that's retaliation for making the complaint, but you can't prove you can't even have a case of hostile environment, and unlawful discrimination unless you complain about it. So we're just not sure why you need retaliation in addition to those two.
Well, it is certainly discrimination.
Yeah. Thank you.
Thank you.
At this July 13th meeting,
Yes.
the investigators report characterizes the complainant's conduct in that meeting as cooperative. Can you tell me more about that meeting? What did the complainant do that could reasonably be characterized as rude?
Yes, so this meeting, just as context, was called in, she was told she needed to come to a meeting the prior June, that there'd be a meeting in July and HR would be present. So my client goes to the meeting and the meeting starts out with the HR person saying, see, we wanted to meet with you because we want to know what's going on. She wanted to know why she's making asking my client, why are you making false allegations? So it started out with gaslighting. There had been no discussion about her complaints about being assaulted. Priest admitted what he said during that period of time. There were admissions that he in the record that he threw papers or that he slammed them on the desk. But yet this meeting started out with, you're trying to accuse somebody, and I quote, accuse somebody of something that didn't actually happen. So that's the way it started. And my client was there 3-on-1. She, during that meeting, said to them, I am upset because of priest's abuse. And then she asked, what did you do about my complaint about the assault and the abuse? And the answer was, and I quote, there is a process that happens. This is HR. I don't even know what happened. I've just been assured that it has been addressed. The way it was addressed was shutting her out and freezing her out and giving her the silent treatment. And she said, and that is how the church works. That's what the HR person told my client. And my client said, I got nothing from the church. And she said, we took care of the issue. That's the support. And my client said, you didn't tell me. And again, if you, let's see, and then it just goes from there. There's an absolute failure to address the assault. So this is not even close to a corrective meeting to address my client's complaint. It's more, you are saying things that are not true. And so the investigator found fault with my client, apparently, because it was a tense meeting. My client was upset. But the important thing to remember here is that there was no terminating my client because of this meeting. My client took the information, took the paper that they gave her, which the first point, it was already all written up, the accusations and rumors must stop. And that was really terrible for my client. She was in a no-win situation. She made reports, and the emails that she sent to HR were very clear and balanced. And she even said with her first email, I don't know if I want this to be reported. She was scared. She just wanted it to be over. Instead, she got what she got. And this meeting was a very tense meeting, but it was a situation where it was a real setup where she was being disciplined for, quote, telling false making false statements in essence, and that was far from the truth. Thank you.
Commissioner questions for Attorney Aiello? None, you'll have 2 minutes when we come back to you.
Thank you so much. Appreciate it.
Adam? Do you want to reserve any of your time?
I'd like to reserve just a minute. Good morning.
I'm sorry, my client can't hear. Is there a microphone or there's not? Okay.
Maybe just checking.
Okay, if you don't mind, Attorney Haddo.
Sure.
Thank you so much.
Good morning. In large part, the complainant's issue with the findings of the investigator really has to do with the evidence that the investigator balanced, the inferences that the investigator drew, and much of that has to do with the investigator's observation of the witnesses during the INR conference. We had a long INR conference in this case. 4 witnesses testified. The complainant testified, and there were three witnesses from the respondent, the HR director, the office manager, and the priest. So the investigator had the opportunity to observe the demeanors of all of these witnesses and draw inferences as a consequence. Much of the complainant's account of the events is drawn from her complaint. And her complaint obviously presents only her perspective, one side of the events, the signal events in this case. What's important here, as an example, is the event involving the priest, what's being characterized by the complainant as the priest throwing papers in her face. The priest testified that that was not what happened, but more importantly, the office manager who testified that she was present when this event occurred, testified about the event, denied that any papers had been thrown at anyone, and actually testified that given the circumstances that had led up to that event, she felt that the priest had exercised reasonable restraint. He had spoken angrily to her, he had slapped papers down on her desk, but this was a consequence of numerous repeated errors that the complainant had committed in one aspect of her job performance. So, and that's just one example of where the events, as described by the witnesses, didn't conform to the description that the complainant had made of those events. The fact of the matter is that with respect to the disciplining of priests within the church, that is a unique circumstance in the world of employment. The law court has long held that it doesn't reach into, the state doesn't reach into the disciplining of priests by the church. That's a First Amendment issue. So that's why when the HR director said, I don't really know what goes on there, it's really, it is what it is. That's why that happens, because that is a unique circumstance. All in all, the investigator in this case did an extremely thorough job of reviewing the documents that have been presented, the written submissions of the parties. As I said before, the lengthy INR conference. The witnesses, by the way, were sequestered during the INR conference, just in case you're not aware, I'm sure you are, so that they didn't have an opportunity to hear each other. So when witnesses were consistent with each other, it wasn't because they were listening to each other. And so in this case, almost everything turns on the facts. Almost everything. There's very little dispute about the law here. It's really about the facts. And that's where the investigator is actually in a unique position to make an assessment. And in the view of the respondent here, the Roman Catholic Bishop of Portland, the investigator made the appropriate assessments based on the testimony and the evidence that were presented. So I'd be happy to answer any questions if there are any.
Questions for Attorney Hadow?
Yes. Is the July 13th written warning the one that says the false allegations have to stop?
Yes, correct.
It's rather loaded, isn't it?
Well, so here's the thing. Let's suppose for the sake of argument that the allegations were false and that there were repeated false allegations. In that instance,
After what process?
so the process that occurred, so first of all, the HR director had an opportunity to speak with, among other people, the office manager, certainly the priest.
But not her.
Oh, but certainly also, you're talking about the
The
complainant?
HR investigation of the complaint, does that include her?
Sure. I mean, the complainant had adequate opportunity to talk with the HR director about her complaint.
Other commissioner questions for Attorney Hadow? About 5.5 minutes of meeting.
Thank you very much.
Attorney Aiello, you have 2 minutes and 2 seconds.
Thank you. There was never a process. There was never a process where there was a follow-up from HR to my client. My client wrote detailed emails, and I disagree with Attorney Hadow on a number of things. One of them certainly is that the record contains citations in my submission that came straight from the respondent's submissions to the commission. They came straight from the respondent providing emails that my client sent to HR with detailed information about the harassment and the abuse. There was never any follow-up from the diocese with my client, except the accusations need to stop. That's it. It was based on nothing. And I do think that there certainly is not just based on a disagreement of facts. The investigator absolutely got it right when she found that there was a hostile work environment. Where we differ is on the law, on whether or not the diocese is liable for that hostile work environment. We all agree there was a hostile work environment. But the question here is, how is the diocese liable? And we know that the law says that if there is a tangible employment action that happens as a result of the harassment, then there's automatic liability for the diocese. Now, the diocese, that's true here. I've already talked about that. I'm happy to answer any further questions on that. But let's say the diocese, a way that a respondent can get out of liability is by engaging, of course, in the defense about whether or not they took care, reasonable and prompt care. Now, it's hard to imagine not looking into a complaint of the detail that my client sent and not undertaking an investigation and at least give a fair chance to my client and to the diocese.
How many emails are there?
Let's see, there were several, one in April complaining of the assault. And then there was another in later in April, I think April 11th and April 20th, where she said the subject line was nonstop aggression, please help. And that included when the priest came and did the throat motion, cutting the throat. That was the second one. And then there was another one following after the diocese, after the bishop or Monsignor directed the priest to not have contact with my client. And then my client emailed HR again to say, I don't know what to do. I'm bypassed by all communications. So those were some of the central ones, but she didn't get anything back.
Good morning.
Morning.
So I'm looking at the investigator's report, and if you've already said this, I apologize. But I'm looking at paragraph 8, under the age discrimination heading, and It says, I'll just read it, it says respondent provided a discharge complainant because of her combative and uncooperative behavior following the April 2023 altercation. At their meeting, director issued complainant a written warning which listed several actions that complainant needed to complete or correct if she wished to maintain her employment with respondent. I don't see any of those actions listed in this report or in the submission. What were those?
Oh, excuse me. So that was the written, this was it. It was dated July 13th. And it says, as we discussed in our meeting today, in order to move forward with your employment here at the parish, tangible employment action, the following items need to happen. One, the accusations and rumors need to stop. And then you need to be present at work. I guess it was some complaint that she didn't put in a vacation request. She's an employee there for almost 20 years. You need to be pleasant and positive with coworkers and people who come to the office. All recording and video equipment need to be removed completely from all offices in the building. Documents that need to be accessed by staff are not to be password protected. You must comply with all office procedures that have been developed and implemented. All parish property that was removed needs to be returned immediately to the office. If you have an issue, please bring it to, and then there's a blank, attention as soon as possible. We can't address what we don't know. It's signed, and then there's a signature line for the employee and a signature line for the supervisor, which is the priest who signed this document with the first requirement, all accusations and rumors need to stop. This is not corrective action. That meeting was not corrective action. I'm going outside what you asked. I'm sorry.
It's fine. It's fine.
Thank you.
Yeah. Okay. And I've heard you explain some of these things. I'm just gonna go ahead and guess your position is that that entire list, there's no merit to any of that.
You know, I don't think my client was an employee of almost 20 years and there was like a misfired email like a number of years ago that was noted in the record. But yes, I think that this was a setup. I think that this was a complete setup to send her a message.
She was on her way out.
Yeah, absolutely. Thank you.
That wasn't anything but.
So there's a disagreement about the diocese responsibility for the priest action? He didn't make that argument. I mean,
Can you say that again? I'm sorry.
the diocese, you said that there's a disagreement about the diocese's responsibility for the priest action. Nobody's made that argument.
Oh, no, I must have misspoke. I think what I was getting at, there was a statement saying that this is really a disagreement about the facts. And my point was, we agree on some facts, but we also disagree on law. I think council has suggested that there was no disagreement on law, and there is a disagreement on law in terms of the first point that I tried to make about tangible employment action. And
there's no disagreement about the comments referring to age by the priest, right?
There certainly isn't, as far as he admitted at the IRC what he said, right? Yep.
Questions? None.
Thanks so much.
Maine Haddo, you have 5.5 minutes.
I'd like to make 2 points.
Can you speak up, please?
Yeah, sorry. I would just like to make 2 points, please. First, as to the issue of the escalation of action that was described by the complainant following the April 2023 complaint, those are some of the facts that are most hotly contested and as to which the investigator made findings that were not consistent with the complainant's claims. For example, the claim that the priest made a cutting motion across his throat and said words to the effect of your days are numbered or you're done. The investigator did not find that happened. And the testimony, there was testimony to the fact that it did not. The comments about the adult diapers, again, there was a lot of testimony about that. And the testimony was in great measure inconsistent with the account that the complainant has made. And that goes to my second point, which was in response to your question. The priest absolutely admitted that at one point he did say to the complainant words like, you may be aging out of this job or you may be getting too old for this job. As to all the rest of the claims, that was contested. And in fact, you'll see in the investigator's report, the priest said no, didn't say that. And the office manager said, no, didn't hear that. And her desk was immediately adjacent to the complainant's desk. Those are the only 2 points I really wanted to make. I'll be pleased to take any other questions you may have.
Commissioner, questions for Attorney Hadow? Thank you. We've heard
Thank you very
from
much.
parties, and next we'll hear from investigator McCarter.
Good morning. Just a couple of things that you commented on. The conversation that the complainant said she had overheard about other people getting a raising on her was in March.
Sure.
Sorry, the conversation about the potential raise was in March, and the report wasn't until April, so that was before that. There's no evidence in the record that the respondent ever removed computer access from the complainant. They checked with their IT department, and there was an error with I don't know if you understand how multi-factor authentication works, where you have, you try to get access to something and it comes up on another device. So that would have been, but the complainant was not going to the next step to authenticate their access. Yeah, I think it's clear that there were many statements about what happened on both sides that were really at odds to one another. Any questions?
Commissioner David and then Commissioner David.
If there are these claims that there are these factual disputes, why doesn't that cry out for a trial? Why
So
are we
it's
second guessing the standard of equally likely to succeed?
Well, when we analyze a case, we look at the facts that we believe in the case and make a determination or
And-
facts. And there was nothing in the record to support complainant's claims other than I don't remember, the altercation and the comment about age. There was no support in
Okay,
the
so there's
record
multiple
for-
comments about age. Aren't those
Right, but those were
sufficient?
all disputed. Nobody that I talked to on behalf of respondent had heard any of those comments. And that also went for comments related to sex and comments related to religion.
Thank you.
Curious about the written warning, and in particular, you know, in your report in paragraph 25, that the written warning itself does not constitute an adverse employment action. I also heard the ILO reference a memorandum from council. I think it was dated to 2010, that contrasts with that conclusion. So can you tell me more?
I don't recall that particular memo being entered into the record of,
Don't look at me, Colin reviewed this case, so I don't
recall seeing that actually.
I don't recall that.
but it's also on our website. You can take notice.
Any other commissioner questions for investigator McCarter? Thank you, Carrie. So we've heard from the parties and the investigator. This time we're looking for a motion. There are 3 proposed findings.
Yes, there are three.
Three and a recommendation.
I was waiting to see if there would be a positive motion to adopt these findings, and I'm not hearing any. I am persuaded that there are reasons. So
On all three or? On all three findings or on one?
That's what I'm torn about.
Okay.
Yes. On all three. But there are reasonable grounds to believe that it's unlawful discrimination.
Do I have a second? Seconded. Discussion?
In support of the motion, it's so rare in these age cases that we have to be, and we look for it and we don't find the explicit reference to age, and there are multiple indications of age being a motivating factor here. I think that the investigation of her complaints is wholly inadequate. I'm not questioning the fact that I'm not saying that we get to review the church's internal policy, but they have some responsibility to deal with the complainant in terms of saying that they've investigated and there's no change. I think that June 13th meeting was a setup. I think there is discrimination.
So in sort of analyzing this in terms of an even chance standard, right, and how this all plays out at trial, what I envision is that Attorney Aiello, her client, will present evidence, all the statements are listed in her submission, objection to the investigator's finding, which says there are all these age-based comments, right? And respondent will have some evidence to refute that, as they did at the Issues of Resolution Conference. Then after these reports are made, I mean, I guess there'll be conflicting evidence as well as to whether or not the complainant was actually shunned by the gentleman that she was supposed to be working for, right? She's basically shut out. And then there are all these competing allegations, I guess is my point. And as I sit here, I've been torn by all of this. As I sit here and listen to the competing accounts, I don't know how this comes out of trial. And so I think even chance standard is applicable here. I do. I think that complainant could prevail, and I think the respondent could prevail. And that's the essence of the standard.
Seeing none, the motion is to find reasonable grounds on all three recommended findings. If you vote yes, you are in favor. Commissioner Davis?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay. Findings are reasonable grounds. We will send the parties and council a letter concerning next steps.
Next case for hearing is. Take a break. Sure, okay. 2.5 minutes. Thank you for, yes, coming to order. The next case is Janet Echeverria versus Maine Youth Alliance. The recommended finding by the investigator is for finding of no reasonable grounds on all three counts. Therefore, we will hear from the complainant.
I just want to note before we get started, I know Ms. Echeverria socially a little bit. I obviously was not involved in the investigation, but I'm happy to go sit in the back and let Barbara keep time and run the discussion if you feel that's necessary.
No,
Are you okay with that?
we're okay.
Okay, great. Then you have 10 minutes if you'd like to save any of that time to respond. Okay.
My statement should be less than 5.
Okay, great. Whenever you're ready.
Hello, my name is Jay Echeverria, and I really appreciate you all taking the time to hear what I have to say today. So I believe my case follows the even chance standards for reasonable grounds based on temporal proximity. The warning that I received in the email was sent at the same time as the final decision for the harassment claim. It falls under grounds of retaliatory animus because the change in my job description was an act of retaliatory animus. There was micromanaging of my work post the harassment claim, pushing for me to quit post the harassment claim, scoffs and eye rolls during meetings, and aggression post harassment claim, forcing of conversations about the harassment claim, despite my request to wait until I had a lawyer present, which I was actively seeking, and the fact that they fired me. I received different treatment. I was expected to do admin work and executive director work, additional labors that other staff were not expected to take on, and they did not lessen my workload. They changed my workload post harassment claim, and which is a tangible employment action, which included an additional tangible employment action would be the isolating me from other employees and the youth. Last of all, I question what the policy grounds for firing me were, and if this was in fact a departure from their own policy. I want to let you all know that I loved this program. I grew up going to peer mentored Friday nights as a teen and in middle school, and developed beautiful friendships in this space. I was thrilled to be hired. On my 60-day review in February 2023, I received abundant praise and encouragement from the respondent. I was certain I'd found a permanent workplace where I could thrive. Nonetheless, when I came forward to the respondent about continuous unwanted behaviors from my coworker, I was surprised by the outcome. From that day forward, the respondent completely transformed our relational dynamics. First, the respondent encouraged me to file a harassment claim and then proceeded to harass me for doing exactly what he instructed me to do. I blew the whistle because my experience of sexual harassment was one of many situations of sexual misconduct reported to me during my time working for the respondent. I saw a workplace I adored with an incredible team confronting not only a health and safety crisis, but also a liability with the potential to lead to a class action lawsuit. My efforts to address these issues came with the intention to protect our programs and ensure their longevity. I blew the whistle and the respondent changed my job description and ultimately fired me.
I made clear what I observed on the job was a health and safety violation, which is exactly what I am supposed to do as a part of upper management in a nonprofit setting. This is my whistleblower claim. Under the circumstances, in the evidence provided, it is clear that a fair-minded court would find something here. I am certain my claim makes the 51% standard for reasonable grounds, and that the falsities in the respondent's statement will be obvious to a fair-minded court. Thank you. That will be all from me.
About 5 minutes and 20 seconds left. Any commissioner questions for me? Seeing none. Attorney Franco, do you want to save any of your time?
I'll save 3 minutes.
Okay, whenever you're ready, go ahead.
Good morning, commissioners. Thank you for your time today. My name is Mark Franco, and I represent the respondent in this matter. My clients, Patricia and Ray Estabrook, are also on the Zoom. They will not be speaking, but they are. You can see their faces on the Zoom. Patricia and Ray were essentially the architects of the Maine Youth Alliance program and operated that program from 2002 to 2023. They retired as co-directors in June of 2023 and then stayed on in an interim basis for about a year. And then the Maine Youth Alliance actually closed in February of 2025, so it no longer exists. But getting to the root of the matter, I would urge the commission to adopt the investigator's report and find that there's no reasonable grounds. I'm going to skip over the claims, alleged claims of sexual harassment, discrimination, and also discrimination based on orientation or gender identity, since that doesn't appear to be, that appears that is conceded by the complainant in this case, because her submission, their submission does not make any reference to those. I'll be happy to answer any questions about those two claims, but I think that they are outlined in detail and dismissed by the investigator in their report. I'll focus on the WPA claim. The timeline is that there was, it's important to go back to January of 2023 and what happened there during a board retreat. And then there were also, and this came up later on. It was the issue that came up during the board retreat is outlined in the report. It's also outlined in detail that I don't know if the board commission has my response to the complaint, but it's outlined in there as well. But you fast forward to March 15th of 2023, and that's when the complainant made a report about a coworker, and specifically indicated in that email complaint they weren't making a sexual harassment claim against the coworker, but the respondent considered it to be a sexual harassment claim and treated it as such, and undertook a detailed investigation into that claim, the results of which are part of the board's file as part of our response in Exhibit C. So there was a complaint about a coworker, and as it would turn out, the coworker ended up making a complaint against the complainant, and there was an investigation into both. It was basically a mutual workplace harassment claim. A investigation ensued, and the result was a report and guidelines for both people to follow so that they could continue to work together. The coworker agreed to those guidelines and the complainant did not. And then there was a training session on March 16th of 2023. And there was a lecturing by the complainant about childhood sexual assault. It had the online training had nothing to do with that. The complainant was told that her behavior was challenging and confrontational and totally inappropriate. And then the reason why there was a written warning dated April 4th was because of the March 16th online training, but there is reference in the April 4th written warning to the January 16th matter at the board retreat. It's likely that the respondents would have considered that to be sort of a one-off and not important, but for the repeated behavior in March. And that's why it was included in the April 4th written warning, which you should have. And it does say, we have concerns that you cannot set proper boundaries when it comes to your personal political beliefs. I'm aware that you have strong negative opinions about a member of our board of directors. I have concerns you may share your strong opinions among other stakeholders, et cetera, et cetera. Outspoken opinions are not professional nor appropriate for the workplace, et cetera. So that was the April 4th warning. It's very important that the board understands, that the commission understands that following that, there was a sincere attempt for there to be a collaborative effort so that the complainant could continue to work at the at her job. Mr. Estabrook in his staff, him specifically, engaged in what he would describe as a collaborative problem solving technique and met with the complainant on 3 occasions to address the concerns that they had. And one of the most important issues relating to that was the fact that the complainant was trying to change the mission, vision, and value of the alliance. They were trying to change it from what the mission statement was to have it a positive youth development organization, tried to change that into a youth mental health and trauma abatement organization. And those mission statements are completely detached and different. And it was important. And there was an email that the complainant made in the course of her employment, in which it was obvious in that email that they did not understand the mission statement. The second issue was the continued inappropriate and unprofessional conduct. So the complainant only worked for the respondent for like 4 months. And when I see personnel files for people who work 4 months, it's like three or four pages, onboarding information, payroll deduction information, health insurance information. The complainant's personnel file in this case is like this thick over 4 months. It was just repeated email after email after email, response to the point where they just were not getting anywhere with them.
Attorney Franco,
yes.
I'll let you know you have finished 7 minutes. I've started another 3-minute timer.
Okay, I just have 30 seconds. Basically, if you review the dismissal letter, you will see the reasons set forth in the dismissal letter it's an April 27th, 2023 dismissal letter. I just ask you to review that. And when I go back for my 3 minutes, I'll read some of the portions of it. Thank you.
Commissioner, questions for Attorney Franco? Seeing none, Ms. Echeverria, you have 5 minutes and 14 seconds if there's anything you'd like to add.
Yes, I worked for the respondent for 6 months, and as a professional who has developed previous youth programs, I developed this program in Claremont, California, for the Claremont colleges. I am used to legal liability standards of working with children. The reason I asked that question in the meeting with the director of AmeriCorps was because I was told in January to review the sexual harassment policies and therefore asked a question in regards to the sexual harassment policies that I felt was typical liability standards for a youth program, having experienced working with over 5 lawyers to develop a youth program. I was not trying to change the organization. I was just trying to follow liability standards that I was used to as a professional in the realm of positive youth development. I do not wish to dismiss any claims that I have made. I believe there's reasonable grounds in all my claims. I believe I engaged in protected activity, that there was a safety issue that was objectively reasonable, that tangible employment actions were taken against me. I refused to sign the harassment claim, the finalizing of the harassment claim, because I did not agree with the conclusions, and I was actively seeking a lawyer to review that claim to ensure that I wasn't putting myself in a position, an inappropriate position legally, by signing a conclusion to a claim that I disagreed with. And then if the staff training in January, if there was an issue with that training, why was that not brought up to me in February at my 60-day review? Why was that never brought up to me until I got the sexual harassment claim conclusion and simultaneously a warning? Why were those warnings never addressed with me prior to the receiving of the final decision on the sexual harassment claim? So that's all I have to say. I really appreciate your time. And I think it's probably time to hand it over to the investigator, unless you all have any questions you'd like to ask me.
Morning.
Good morning.
Yes, I appreciate you appearing here on your own behalf.
Thank you.
Yes. With respect to your whistleblower claim, I just
Yes.
want to make sure I understand what the allegations are.
Mhm.
My understanding there are 3, basically, right? One is this written warning that you were just talking about.
Mhm. Mhm.
Okay. And then you say that you were, the record shows that your job description was changed after the sexual harassment investigation was concluded.
Mhm.
And I think you characterized that as a demotion.
Yeah.
Your statement?
I was supposed to be in charge of, I was the director of programs for 2, well, technically 3 youth programs. And I was removed from any contact with the youth and no in-person contact with staff. And I essentially was switched over to admin duties that I was never trained for. So I was assigned to work on the Excel sheets and get people's hours and things like that I'd never been trained to do, and was not actually in my professional scope or in my job description, my original job description at all.
So you were changed from more of a role where you were interacting with other folks at the organization to a role where you were more isolated.
Exactly.
Okay. And then the third thing would be your termination.
Yes.
Thank you.
Thank you so much.
You are pressing a sexual harassment claim for which the standard is that it be severe and pervasive harassment. Is that correct?
Yes.
And describe that severe and pervasive.
Or pervasive,
Excuse me?
severe or pervasive.
I'm sorry,
One or the
severe.
other.
So the pervasive harassment was what I received from the respondent after submitting the claim, which was continuous pressure to quit, isolation from the rest of my job space, a change in my job description. The warning was given to me post the sexual harassment claim. I had those 3 meetings that are mentioned, and during those meetings, I was told that I don't like my job and I don't want to be here. And when I would say, no, I do like this job, I really like this space, I was given eye rolls and scoffs.
Is that the retaliation claim?
I would say it falls under both, because it's both pervasive harassment and also a form of retaliation, as it is aggressive behavior.
Okay, I asked you what the severe or pervasive sexual harassment was, and you refer to what happens after you make the complaint. Right?
So that is, so my severe, like the pervasiveness, the pervasive harassment was what I received from the respondent, as opposed to the pervasive harassment being about the original claim. It was that I put in a sexual harassment claim, and the pervasive harassment that I received was that from the respondent, not the coworker.
Okay.
Thank you.
Thank you.
Attorney Franco, you have 2 minutes and 10 seconds if there's anything else you'd like to add.
Just briefly, again, I would go back to the dismissal letter and have that be part of your review. But I think there was a job change in terms of the percentage responsibilities of tasks, because they were not completing their tasks as per the original job description. So when you can't compare the original job description to the revised job description, it went from 40% operational to 80% operational and 40% program to 10% program, because they were not completing the operational part of the job. And they essentially wanted to have their own job description where they had basically all direct contact and no administrative duties, and that was not the intent. As far as the pervasive sexual harassment issue, one comment was made by a coworker in the course of a meeting in which they were talking about a role-playing game, and they used an example of a game called Dungeons and Dragons, which I've never played, so I don't really know what it's involved. But in that context, that coworker used the word brothel. That was it. That was the only, and they took offense at the use of that word in the context of that conversation. There was no pervasive or harassment, sexual or otherwise. And what was the other point? Essentially, it was, again, the attempt was to get the complainant to get on board with the mission of the program and to stop complaining about unwarranted complaints about coworkers and supervisors, which the results of the harassment investigation are in the board file. The investigator reviewed everything, and this doesn't meet the 50-50 or 51-50 standard. Are there factual disputes? They're always in every. Yeah.
That's your time.
Thank you.
Commissioner, questions for Attorney Franco? Seeing none, we've heard from the parties. At this time, we will hear from Investigator Carter.
Good morning. Any questions?
Cut right to the chase.
Brief and to the point.
Any commissioner questions for the investigator? Okay, thank you, Carrie. We've heard from the parties and the investigator. There are 3 proposed findings. At this point, we'd be looking for a motion.
To adopt the recommendations from the investigator as written in the report. Number 1, there are no reasonable grounds to believe respondent discriminated against the complainant on the basis of sexual orientation or gender identity. 2, there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of sex. Number 3, there are no reasonable grounds to believe that the respondent retaliated against the complainant for engaging in MHRA or and or WP or W activity, and 4, the complaint should be dismissed in accordance 5 MRS section 4612 subsection 2.
Second.
Moved and seconded, any discussion?
So, I appreciate your presentation. I think that, you know, in terms of the claims that you stated, right, we have to find that there's evidence that you were discriminated against, for example, number 1 here on the basis of sexual orientation or gender identity, or on the basis of sex. And there really isn't anything in the record that gets us to that even chance standard on those two. Your Whistleblower Protection Act claim is closer. It's a closer question. But I think that, I mean, your claim is against the Maine Youth Alliance, right? They have a duty to investigate your claims, right? And they have a duty not to retaliate against you for making claims. And I just don't, I hear what you're saying, but I don't really read in this record that that's what happened. It looks to me, and that's why we went through the 3 things, right? The written note, the written warning, and then the job change, and then the termination. And with respect to the last one, the termination, the record shows that they met with you at 3 separate days before they terminated you. So I think they satisfied their responsibility to do what they were supposed to do, and I don't see that you retaliated against theirs. I don't see that you meet that even standard. But I do appreciate your presentation. I appreciate you showing up here today on your behalf.
My only concern or rebuttal to what you just said is that 3 meetings over 5 days, in the middle one, there was a request to wait for review of legal counsel. It doesn't seem like they accorded that, and in some cases that would have been fatal, but they didn't. I'm struggling with that, and I don't know where it fits in within the 3 motions, so.
Well, let me respond.
Yes, please do. Clarify for me.
Before Commissioner Sanders jumps in, I think that everybody, it's important for everybody to keep in mind that this is an at-will state. That people can be terminated for any reason or no reason at all, as long as it's not discriminatory, as long as it doesn't violate the law. And I don't know after the investigation of all the water, the thick personnel file that Attorney Franco referenced, that having an attorney present or not present would make a difference. It's not a criminal case.
I don't know.
Right to counsel. I get what you're saying,
But my concern also is that if I understand the presentation in the facts correctly, there was a request to sign an agreement 3 or 4 days before she was discharged. And that was about at the same time she requested assistance from an attorney. And if you're being asked to sign an agreement that you disagree with, I think that's a fair request. Well, I know it's not criminal. I don't know.
what was the agreement?
Her.
What was there?
Yes.
Excuse me.
Mixed activity uses they pronouns.
It wasn't the termination agreement. It was
The job description?
Is all.
changing
Because
the
I think
job
that was
description.
right. The job description changed at the conclusion of the
So I'm
sexual
reading
harassment investigation, but doesn't say exactly.
on April 21st of 2023, that they were presented respondents' written warning and asking for her to agree with that, they to agree with that. And complainant is legally allowed to discuss concerns about safety, including mandatory youth reporting and certain retaliation. And if they disagreed with that and wanted to have it reviewed by counsel, I think that's a fair request, and it doesn't seem like that was given any credence because it was 6 days later that they were discharged.
There was another meeting on the 24th.
Yes.
They just way out there. So, and I'm not trying to suggest we have to litigate also on some sort of rocket docket timeline, right?
No.
But between the 21st and the 24th, I don't know if that's a weekend, I don't know what that is, but
Yeah.
it seems like your council on board, you have to call and say.
Yeah.
Yeah.
Okay.
I guess what I'm saying is, I don't know that it's making it. So, yeah. It's an interesting conversation.
Further discussion? Seeing none, the motion is to find no reasonable grounds on all three recommended findings. Vote yes, you are in agreement. Commissioner David,
Yes.
Commissioner Walker,
No.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
The findings are no reasonable grounds. The commission will send a letter to the parties and the council confirming the results of the hearing. I believe that Investigator O'Reilly has the menu. Will get your lunch orders now and put them in. See if we can get the next case started.
Second to.
You take a couple minutes.
Yeah. A couple of them.
I'll be right back.
Okay, the next case for hearing is Delison Taveras versus Nichols Portland LLC. The recommended finding is for a finding of no reasonable grounds on both counts, and therefore we will hear from the complainant. It's online.
He's right there, yep. Right, and that's my cue. I'm trying to do too many things at once. Mr. Tavares, you have 10 minutes. Do you want to reserve any of that time?
I'll use my 10 minutes.
Okay.
Thank you, the commission, for my opening statement. I think the investigation recommendation of finding of no reasonable ground. I said that the investigation was incomplete, biased, and legally deficient, and that the record supported and finding that reasonable grounds existed to believe that unlawful harassment and a retaliation occurred. The reports acknowledge conflicting accounts of the September 14, 2023 incidents, but the respondent's management, by recognizing the respondent threatened me physically, yet no witnesses' statement were taken despite the presence of a co-worker, supervisor, and the other lady from the other office behind. The failure to obtain available testimony unfairly elevated the respondent's denial above my accounts. The investigator relied heavily on the respondent's self-reports and apology as evidence against retaliation. Accepting self-serving statement without corroboration demonstrated bias and undermining the neutrality required by MHRS investigation. The report admits that the threat of physical harm, if made, could be sufficiently severe for hostile work environment. Claim, however, it dismisses the allegation solely because it was not explicitly tied to race. The Maine Human Rights Act 5, Section 4572 prohibits harassment that creates an hostile environment, and physical threats constitutes unlawful harassment regardless of whether racial language was used. The reports improperly use the fairness malfunction incidents and justify for termination. This event is unrelated to harassment or retaliation and served only to distract from the protected activity. Its inclusion demonstrated improper weighing of irrelevant evidence. The reports concede that termination occurred 2 weeks after protected activity, which established a prima facie case under the DeSantis v. Michaud on 99. This is the main case. Instead of applying the proper burden shifting analysis that the investigation dismissed retaliation based on speculation that performance issue were true reason. This failed to recognize that temporary proximity and the circumstantial evidence are sufficient at this stage. I reported being threatened with violence. The investigator failed to consider the employee duty to protect employees. Sorry, the investigator failed to consider the employer duty to protect employee from physical aggression in the workplace and fundamental obligation under Maine MRHA section 4572 subsection 1A. The report accepted that respondents record email and self-reports and credible while faulting the complainants for lack of documents, even though the employer controlled most of relevant record. This imbalance illustration clear investigative bias. The reports acknowledge both protected activity termination closely followed the activity, yet concluded no retaliation. This is internally inconsistent and undermining the no reasonable ground recommendation. The investigation report relies too much on the respondent narrative, disregard key evidence, and applies legal standard incorrect, given the sensitivity of alleged threats, the close temporary links between protected activity and termination, and the absence of fair witness investigation, that there are sufficient ground to believe unlawful harassment and retaliation occurred. Yes, that's me. In my 10 minutes, if there's any question, there's the Council of Nichols. I can answer question if there's any.
Yes, Commissioner Douglas.
Yes, good morning, sir. I appreciate you appearing here on your own behalf. So I've read the report carefully, and it seems to me that, you know, correct me if I'm mistaken, but your issues at work started when you had this new manager, right? This manager starts supervising you, and all of a sudden he's got all kinds of issues with your job performance. Is that true?
Yes.
All right. What I'm trying to understand, I mean, I see these incidents here where you know, there's the incident on September 14, 2023, where the manager loses his temper and threatens you, right?
Yes.
And then you know, there is a furnace malfunction, and there is an account of that, what happened. You know, they say that you were there and you refused to provide the names of other people that were there at the time. And that's fine. So, and then you meet and you're terminated. What I'm trying to understand is what evidence is in the record that any of this had to do with the fact that of your race, your color.
Yeah, if you go on the August 11, which is not accounted, I talked to the supervisor that we are not in Jim Crow South. I told him like that because of the way he was treating me. He was treating the second shift because of a South Sudanese guy plus me. I was managed most like the people of color. My second shift, majority of people of color was managed, Asian and all things. If he say there will be no reason for me to say we are not in Jim Crow South when people are afraid to give their statement or to talk, and they be ending up as a news hanging in their porch. It was never mentioned during the investigation because of everything that the manager was doing. I'll come, my shift was 8 hours. I work, me and my work leader, we work 12 hours. We have to babysit the other shift. Otherwise, it would be more like a issue behind issue. And going back to the incident of the 14th of September, we had nothing to do with that. He was doing the shift change. I was assigned to work 8 hours, but I'll come, like my shift started at 2 p.m., I'll come at 12 p.m. and I'll leave at 2 o'clock in the morning because we wanted to look good. If you see the communication, I attach it. I talked to my work leader. This guy is profiling in the racist way. I grew up in Alabama and Mississippi. I know how racial treatment is. That's why. So there was no reason whatsoever. I've about 17 years working for Chevron, ExxonMobil. I work in Saudi Arabia. I work in the Gulf of Mexico. So I wouldn't have any problem to work for Nickel. So soon that as the respondent came, there was issue by an issue. There was no, if you read my initial report where I submitted to the commission, I put all the example, all defensive example, that's question by question. There were ESA, there were this and that. There were that I can't use my phone. All was just to find a probable cause to kick me out. It was never for my performance. Because if it was for my performance, I conducted 8 industrial investigations for Nichols. 8. As a new supervisor, I conducted 8 investigations. The problem is like they didn't like me to show that I was high potential, that when he came, that was the reason. Because if you go to the section 5 of 5 MRS section 4572, harassment. If I was the guy who harassed a man like any of my workmates being me, it would be a problem. The problem is like if I was to be harassing, like if I did what he did to me, going to somebody of a different race and tell him, I'm going to break you apart, I'm going to tear you, I wouldn't be staying that day. I'll be fired the same day because it's part of the code of conduct and ethics of Nichols Portland book. That's the thing. Yes.
I understand where you're coming from. All right, thank you. Thank you for that.
Any other commissioner questions for Mr. Tavares? Seeing none, you'll have about 5 minutes when we come back to you. Is there somebody here for Nichols? Brenda Maury was sent materials. So here we are. Mr. Tavares, you have 5 minutes if there's anything else you'd like to add, or we can reopen the floor for questions from the commissioners.
Yeah, and I just said, after the incident happened, I went directly to talk to HR. I talked to Catherine Bogdan about what was going on. There was no action taken whatsoever. There was witness, there was Miss Rousseau, there was Danny Roche, Willa Paya, everybody witnessed that.
Oh, please don't, sorry, I forgot to do the confidentiality thing at the beginning. Please don't use the names.
Okay,
of
sorry for that. Sorry, yeah, they were my work leader, the other supervisor, and the other lady from the QA. They were present. They came. The lady from the QA came. He wiped my tears. Said, "No, don't worry. Anything else, I will talk to you." And I went to talk to the HR manager. No action was taken. So from there, my life was living in hell. Each and every time there's an issue here to clean, I was taken away from my supervisory role. I was like, you need to clean the floor, go and mop the floor, go and do this, go and clean the equipment, go and check this, all these things, because I went it just to let me down. That was the issue. So I went for the second time to talk to the HR manager. No action was taken. After 2 weeks, I was gone, just like that.
Okay. Any other commissioner questions for Mr. Tavares? Okay. Seeing none, move on to Investigator O'Reilly.
Are we still in the morning?
Yes.
Yay. Good morning, commissioners. Once again, I was not the investigator who conducted the investigation. However, I did finalize the report, reviewed the entire record. I don't really have anything to add. I think, the report found that there wasn't a connection to race based on any of the actions in the report, but I'm happy to answer.
Your questions for Investigator O'Reilly? All right, heard from the parties and the investigator. I may be looking for a motion. There are 2 proposed findings.
So I'll move that we adopt the investigator's findings that there are no reasonable grounds to believe that respondents discriminated on the basis of race. And there are no reasonable grounds to believe that there was retaliation based on WPA protected activity, and the complaint should be dismissed. Second.
Moved and seconded. Any discussion?
Was he represented by, was the respondent represented by counsel?
Yes, Matt Lamoury, who I have checked. He got the invitation, he got the Zoom link. Not on the Zoom call or here, so.
Bothers me.
Hmm?
It bothers me. That sort of blowing it off. If that's what I conclude.
Certainly take that into account.
There a second.
Yes.
Yes,
Oh, they're-
yep, yeah, we're in discussion now.
I'm troubled by what the complainant describes.
Yeah.
I think many minorities in the United States can imagine such a situation where, you know, he feels like he's being treated differently and, you know, in an unfavorable way, you know, sort of compromised by a series of what I'll call microaggressions. And of course, the altercation there. I'm just not seeing, I think there needs to be more than that in the context of these claims, and I'm just not seeing the evidence that this was tied to his race. And I note in particular that his replacement was a person of color, which otherwise I just don't see evidence that it's tied together. So.
Well, I'm troubled. I find his presentation quite credible, but if you don't see any tie to that, then I think I'll yield to the investigator. It also bothers me that the investigator is not, and Jane is taking over an investigation. Things can get lost in that transition. Okay, I'm done.
But we'll also say I find it quite troubling that the respondent's not here.
Yeah.
That is troubling.
Yeah, I do too.
Why are they not here?
Yeah. Given my interactions with respondents counsel on just a number of things, I am surprised. I don't have any information. All right, any further discussion? So the motion is to find no reasonable grounds on both recommended findings. If you vote yes, you are in favor. Commissioner David?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
So the findings are no reasonable grounds. The commission will send a letter to the parties and council confirming the results of the hearing.
And the next case is Dolores Rondon versus R&K Wellness and Mental Health. It's a public accommodation case. Get this right.
She's not here.
Hello, can you hear me?
Can hear you. Hang on just 1 second, Ms. Grondin. I think Alexander is here for the respondent because Erica is unavailable.
Also, you, Rick, might be the individual.
This might be, yeah, my understanding is she was not available today.
Actually, I am. I was able to join. I got out of my previous commitment earlier.
Okay.
Yep.
And so will you be presenting on behalf of respondent?
Yes.
Okay. All right. Thank you for bearing with us on the logistics on that one. Ms. Grondin, you have 10 minutes.
Good morning, everyone. Thank you for hearing my case. I am not a lawyer and I don't know about the legal terms, but I want you to know that I am a mother who cares deeply about her special needs son's mental health and well-being. He was adopted at 6 weeks, and at 12 years old, we found out that he was fetal alcohol affected. He doesn't have the full syndrome, but he does have some significant mental health issues that cause him problems throughout his daily life. We have had a case manager for him for several years, and one of them we had for about 3 years, which he was doing very well with. I got a message from Erica that they were going to try to change his case manager. And I was not happy with that because one of the things that he suffers with is anxiety, meeting new people and changes in his life. So I tried very hard to get her to reconsider because from what I understood, the only reason she wanted to change Greg's case manager was because the one he had was having quite a commute. And it was the traveling that was putting a kibosh on this. Greg was not the only client that this case manager had, but that didn't seem to matter. So at one time, she suggested that we have a meeting to talk about transition. And I had no problems with that. So we we met. And when we were there, I don't think the meeting lasted more than 20 minutes. We got there. She started talking about, okay, we need to talk about transition. And I kept saying, no, we need to talk about trying to keep his current case manager. I had a letter from my son's doctor indicating that changes cause him a lot of anxiety, a lot of acting out, a lot of wanting to quit all his help because he was tired of all the changes and all the different people that he had to deal with. And I asked her if she had read the letter, and she said yes. And I said, okay, so what is your decision? And she says, we need to talk about transition. I could get nothing else out of Erica that day. That's all she talked about. And so I did talk, at the time, I did tell her that I was going to speak to a lawyer, and I may look into changing case manager company. The case manager company I did not do, only because that would be more changes for him, a new company, more new people, and it would just make things worse. So I did threaten to talk to a lawyer, which I did, and they suggested that I do a Maine Human Rights Commission complaint. So in the meantime, I did do the complaint, and in the meantime, Greg did get a new case manager. What Erica had failed to tell me was that it was a person that he had already dealt with. So he actually knew this lady. She was in another capacity. Now she's a case manager. So he had met her. So that transition didn't go too badly. However, after having this case manager for about 3 or 4 weeks, I would say, all of a sudden this other lady showed up, another new case manager. He had no warning. I had no warning. She just showed up at his apartment one day, and it was a lady called Joanne Blanchard. And I said, what are you doing here? And she said, oh, I'm Greg's new case manager. And I said, geez, that's weird because I haven't heard anything. Nobody sent me a message. Greg didn't know anything about it. She lasted about 2 weeks and quit. She left R&K totally. And I won't give the reason why, but she's no longer there. Then he went back to this other case manager. And I will let you know, she says she's a case manager, but the work that she's doing is nothing compared to the one that he had for about 3 years. My son doesn't really trust her. And in fact, I'm actually most of the time going to the meetings that she's supposed to go to because she either has problems with her car, problems with her home, can't make the appointment. They do get along, but I don't feel that she's a good case manager. So I'm sorry, I'm just trying to get my paperwork in order. One thing that Erica did say is that she thinks that I'm doing it. I don't like being said no to, and I don't like not getting my way. And both of those are incorrect. My goal is to make sure that my son gets the best mental health help he can get. And I felt that that meeting we went to was more of a power struggle than anything. She was flat out adamant that Greg was not going to keep his old case manager. If there had been a better reason than the drive, it was too expensive, I may have thought about it a little more, but seeing she also had other clients aside from him, I don't feel that it was fair that he was going to lose the best case manager he'd ever had. She also said in some of her paperwork that my son did not go to the hospital. He does not have meltdowns. He seems to be handling things. How does she know? She's not the one that deals with him on a day-to-day basis. He has meltdowns. He freaks out when he has to meet somebody new. And all I was trying to do was keep his life as constant as I could. I think I'm sorry. The expense should have nothing to do with the help that they're getting. And the last letter that I had sent to the commission was just a rebuttal on her last paperwork that she had sent in. I had no intentions of going any further with this. I wanted to make a point that her name is wellness and mental health. And I did not feel that she was taking either one of these into consideration, especially when she had a doctor's note requesting a reasonable accommodation so that my son wouldn't have a breakdown. And that did not seem to faze her in the least. And at this point, I am going to stop talking and let Erica have her time. Thank you.
Commissioner questions? Hang on. Commissioner questions for Ms. Grondin. Okay, you'll have about 2.5 minutes left when we come back to you. Ms. Roy, you have 10 minutes.
Hi, thank you very much. So just to kind of go through the phase again, I was aware of Greg's needs for sure. We've had him in services since we opened our agency. So he's been with us since 2018 in one program or another. And so I do understand what his needs are and what the work that was being done. In the transition, I brought, and I made Dolly aware of this, that I brought her letter from the PCP and a reasonable accommodation request to our BHH panel, which is comprised of a psychiatrist, a medical doctor, clinical director, another clinician, and a psych nurse. So they all reviewed his case and was in agreement of the transition. The transition was actually over at least 3 months. So I paid 2 case managers to make sure that this transition went well. I am the one that reviews the client's charts daily. So I review the progress notes and I have check-ins with my staff regularly, especially when there's changes going on for whatever reason, just to monitor the client's needs. And so there was an overlap of case management to ensure that everything was going well and that Greg was in agreement and that he felt comfortable. And when he voiced he was comfortable to us and that we could move on to the next step, and we explained what the next step was, painted a picture, transitioned to the next step, then went back to him to make sure, okay, did this go okay? Just to make sure there wasn't anything. I'm aware of, you know, if there is somebody that has cognition abilities, disabilities, and mental health disabilities, sometimes the information can get lost. And I want to make sure that our clients do understand. So we regrouped before we moved to another phase of transition. And again, I made sure to put in somebody that Greg already was aware of. No services were ever taken away from him. He still had access to everything that he did with the previous case manager. And actually, he could have more if it was needed. So if there's another resource that we need to link him to for services, the case manager now is much closer and can see him more often if that happens. And if it doesn't and he can maintain, then that's where we'll stay. But we gear our services and adjust them as the client needs, and do that kind of back and forth dance wherever they're at. And I think that's it for me.
Commissioner, questions for Ms. Roy? Commissioner Davis?
Can you describe the service area to me and what the move
Oh,
entails?
sure.
Nobody seems to be talking about what seems to be obvious, that if somebody moved and he's not available, was he available to continue to be the manager?
So the client remained, and the case manager's area was moved, yes. And so we made it conducive for another case manager to be closer to the client, Greg, so that, again, if there's something that does happen, or there's another service that's needed that we need to monitor because it would be a new service, that person could go in much more often than the case manager that lives over an hour away. And
Okay,
so
now you've responded. It's over an hour away.
for the previous case manager, yes. The new case manager is 20 minutes.
Thank you.
Any other commissioner questions for Ms. Roy? You will have about 6.5 minutes left. Ms. Grandin, you have 2 minutes and 36 seconds if there's anything else you'd like to add.
Just a couple things. Number one, when we had that original meeting for the, to talk about the transition, I was never told that she spoke to a panel about the doctor's letter. What she said to me, I said, did you read the letter? She said, yes. And I said, are you going to take that into consideration? And all she said was, we are here to talk about transition. She did not want to talk about programs. She did not want to talk about who the case manager was. All she kept saying was, we're here to talk about transition. She did not like the questions that I was posing. And the other thing is after 20 minutes, she stood up, said, meeting done, and she walked out. No, and then everything came through by email. That's when she sent me an email and said that she had spoken to the BHH panel, and they said that there was no reason why he couldn't transition. She also, the new case manager, met with my son with his old case manager one time. He hasn't been asked, of course, he hasn't been asked by Erica because I don't think she's seen him more than once. I have no idea what the case managers are reporting to her, but he was not comfortable for quite a while. He did know this new case manager because, like I said, she was a DLS counselor at one point and who was now transitioned to case management. But it's almost like it's on the job training with her. At this point, I really don't have anything else to add, and I thank you all for your time. If you have any more questions for me, please let me know.
Well, then is it your position that it was unlawful discrimination to require that he get a new case manager after the case manager moved or more than an hour away?
Okay. Number one, the case manager that he had originally had been an hour away for 3 years. So I don't feel that that was a problem at the time. When I was told that they were going to change case management, they were told that the travel time was an issue and it was expensive. That's what I was told. And that was my biggest problem. The other one is that I do not feel that they took the doctor's letter seriously. I think she had it in her head that this is the way it was going to work, and whether I liked it or not, this is what was going to happen. She also failed to tell me that the case manager that they were going to give to my son was someone that he already knew. If she had said that and we had discussed it at that meeting, it might have changed my mind, but she didn't. I didn't find out who it was until the first time her and the old case manager met.
Does it change your mind now?
I wish we could have kept the old case manager because she was more of a case manager than the one he has now. He's at the point that even when
Thank you.
Any other commissioner questions for Ms. Grandin? Ms. Roy, you have 6.5 minutes if there's anything else you would like to add.
Sure. So the meeting that she's talking about, first of all, I couldn't tell her about the BHH because that was the following Wednesday when the panel met. So I brought that information to the panel. I've never received any communication when Dolly says that there was no change in his symptoms. If there was and she had concerns about that, she knows how to reach me. If she feels that staff is inadequate, she knows how to reach me. I've never had her reach out to me on any way, shape, or form, or even to the next supervisor. So if she doesn't feel comfortable going to me, we do have a hierarchy, and there is another supervisor that's right above the new case manager, which has not heard any concerns from her. So the meeting did end when she said that she was going to discharge the client and that she was getting a lawyer. When somebody says that, there's really nothing more for me to say. So in that, you know, all of our case managers have the same trainings. We put them through the same trainings. They have even the same teachers. So if there's no specialty that the previous case manager had that this new one has. So I'm not sure what the concern is there. But again, if she feels like that, she can always go to the supervisor. We can look at doing additional trainings if Greg needs something. That's always been our policy. So I'm just not really sure where that concern is coming from and why I've never heard it. And that's it.
Any further questions for Ms. Roy? Seeing none, we've heard from the parties. Next, we'll hear from Investigator O'Reilly. It's a Jane show today.
Good morning, Commissioners. And for the third time, again, I'm finishing up investigations from a former investigator. So I was not the investigator initially on the case. However, this was an investigation that I actually was pretty intimately involved in as a supervisor. And I did finalize the report, review the entire record. I don't have anything to add. I think the parties have clearly summarized their points and arguments. And the report speaks for itself. So if you have any questions, happy to answer those.
Okay. Thank you, Jane. We've heard from the parties and the investigator. At this point, we need for a motion. There is one proposed finding.
I'll move that we find there are no reasonable grounds to believe that respondent discriminated against the complainant on the basis of disability. Second.
Moved and seconded. Any discussion?
Yeah, I'll just say that, you know, Ms. Gronin is here because she cares about her son. I think everybody can appreciate that, but for the reasons expressed in the report, I just don't, I don't see how providing the same case manager after he moves out of the service area is unlawful discrimination. And I will add that in the report, it's very clear that the provider bent over backwards to try to accommodate these folks and did modify their policies by establishing this panel, establishing a gradual transition plan, et cetera. So, I agree with the recommendation.
Any further discussion? Seeing none, if you vote yes, you are in agreement. Commissioner David?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders? Yes. So the findings are no reasonable grounds. We'll send a letter to the parties confirming the result of the hearing. I think Colin may have just gone downstairs to get lunch. You want to move on to the next case?
Yeah, let's keep moving.
Great, let's do it.
Let's keep going. Last case is Caroline Tebow versus Oak Hill condominiums. The suggested finding is that we find that there are reasonable grounds to believe there was unlawful discrimination, and therefore we will hear from the respondent.
There's somebody here for Oak Hill.
Yes. Is it okay if I grab some water? Thank you. Thank you for your time. It is still good morning. My name is Roland Garrett, and I'm the current president of the Oak Hill Condominium Association Board of Directors. My colleague is Peter Leone. He's a fellow board members. We are volunteers, as you might expect if anybody has ever lived in a condo or association. We are Medicare eligible and proud of it, not that there's anything wrong with that. And we're here to really talk about the report and the issues that we have with the report that was produced by our investigator. And the first thing, which I put in my submission, is that we are governed by the Maine Condominium Act, or authorized, I should say, to operate under the Maine Condominium Act. That really means that we have a declaration, we have bylaws, and those are given to us, the board members, when we come up, when we purchase a condo. These are written before the shovel ever hits the ground. So it's not like we, as board members, can change those, although the declaration and bylaws tell us how those can be changed. And it's a very onerous process. What the Maine Condominium Act suggests, however, is that, and states, is that we as board of director members have the ability to promulgate rules and regulations for our residents to live in. So we're a community of 68 units in Topsom, Maine, and we're similar to other condo organizations on the Eastern Prom or the West End in Portland or in Gardner or Hallowell or Bangor or Waterville. Everybody falls under the Maine Condominium Act. That was not mentioned as a fact or finding in the report, which we thought was an error of omission. The report did go on to state that the complainant is operating under Rule 19, which was promulgated by our board, even though it was before our tenure as members of the board. In that the complainant alleges that she was in compliance with Rule 19 at the time that she opened her hair salon in her residence. And what I would like to do is read to you Rule 19, which says unit owners are permitted to conduct business from their units under the following circumstances. The existence or operation of the business activity is not apparent or detectable by sight, sound, or smell from the exterior of the unit. Well, there is constant traffic coming down the association-owned and maintained road, by the way. This is not a town road. We own it, we plow it, we repair it. It is our road. So 20 to 30 customers per week come by and park in her driveway or in the adjoining or in the street. So it's pretty obvious. The business activity is legal and conforms to all zoning requirements for the Oak Hill Condominium Owners Association. We don't think that is a true, she does not meet that parameter. The business activity does not unreasonably increase vehicular traffic or parking related issues within the Oak Hill Condo Association. Well, clearly with 20 to 30 customers per week, there is increased traffic. We have members of the community who've observed customers
helping their elderly sibling or spouse into a wheelchair, out of the car, into a wheelchair, into her condominium, which does not have a ramp, by the way, up a couple steps to get their hair salon services. So clearly, there is increased traffic. Clearly, there's increased risk for the association because slip and falls, that sort of activity on our road, on our driveways, will result in lawsuits and litigation against our association. The business activity does not increase the premium paid by the Oak Hill Condo Association or otherwise negatively affect the association's ability to obtain insurance coverage. We have been told by our insurance broker that if we allow businesses in our condo association, which is highly unusual, by the way, that our premiums will go up accordingly because of the commensurate risk. The activity does not place an undue burden on the infrastructure of the buildings of the Oak Hill Condo Association. And we would suggest that that is probably true. There may not be additional wear and tear on the buildings, but there certainly is additional wear and tear on the common elements, the road, the driveway, leading up to the condo. The business activity is consistent with the residential character of the Oak Hill Condo Association. Well, we don't think having a business is consistent with the residential nature. In fact, our condo association has used the model lease that your organization developed a few years back under the fair housing portion of your purview, if you will. And the model lease clearly states that the tenant responsibility is to maintain the residential character of that unit. The business activity does not result in a materially greater use of the common area or association services within the Oak Hill. I think I've covered that one. We are fearful of the safety of our members. We are young, we are all elderly in this community. We have increased traffic. We are very concerned about the use of our association properties. And we are very concerned about, frankly, having a business in a community that clearly has covenants, bylaws, and declarations that suggest business is not permitted. Very clearly in our declaration, all of which was provided to the commission. On the other side of that, both Peter and I have autism spectrum disorder dependents or extended family in our families. And we understand how difficult it is for a parent and how game-changing it is for a parent to be, upbringing an adult dependent and needing to maintain a livelihood. But in order to change our declaration, we need 2/3 of our owners to approve it and 51% of the mortgage holders. That's a pretty onerous task, particularly since our association has overwhelmingly given the board direction that businesses are not allowed in our community, per the declaration that we all received when we bought a condo there. I'd like to save the rest of my time and also ask that Mr. Leone be allowed to interject on my time should I have forgotten or failed to mention anything.
Generally, we only have one person present the party, so we'll leave it there. You have 53 seconds left of your 10 minutes.
I'm sorry, how much?
53 seconds.
Thank you.
Is there somebody here for, Commissioner questions for Mr. Barrett? Yes. Right, sorry. I'm calling on you, Irma.
I'll defer to
Okay,
Commissioner
great.
Sanders.
All right, thank you. Good morning. Thank you for coming. We appreciate your time. So you saw in the investigator's report, right, that the Maine Human Rights Act makes it unlawful for a manager of a housing accommodation to refuse to make reasonable accommodations, right, in rules, policies, practices, or services. When those modifications are necessary to give a person with physical or mental health disabilities an equal opportunity to enjoy the premises. So the rule that you're citing, right, that's precisely why we're here. There's a request for you to make an accommodation or a change in those rules, unless, right, you also saw in the investigation report as well, unless you can demonstrate that excuse me, get to the precise language one, please. Unless you can show that the proposed accommodation is unreasonable, demonstrating it imposes undue financial or administrative burdens or requires a fundamental alteration in the nature of the program. I've heard you comment on the hypotheticals, right? So premium for insurance product, safety issues, sort of hypothetical safety issues with respect to enhanced traffic in the facility. Tell me more about, what is your argument that the complainant's request poses what's called an undue burden, right? Either a financial burden or an administrative burden.
Is your question, how are we impacted from a financial or administrative perspective?
Correct.
Well, in order for us to change our declaration, which is filed with the Secretary of State, we need to get 2/3 of our 68 unit owners to agree to that. Secondly, we need to get 51% of those 68 unit owners' mortgage companies to agree to that. So let's just call it 34. If everybody has a mortgage, we have no idea if that's true or not. So we're talking about undertaking a process of potentially 10, 20, 30 different mortgage companies to gain their approval to change the status of our declaration. We don't have employees. We don't manage the housing. We're just owners.
How did you draw that conclusion?
How did we draw what conclusion?
How did you draw the conclusion that making an exception to the rule that you cited?
That's very clearly written in our declaration.
Right, but how did you decide that making an exception here required you to ask permission and get authority by 2/3 of your condo owners?
Well, we decided that because the language is quite clear that any change to the rules in the declaration, and I do have the declaration here, if I might refer to it if you want to pursue this further, requires, it's very clear, it's prescribed how we are able to make changes. Just the same way it is as to how we are able to make rules.
Barbara. What's that? Curious about the representation, if you can, and you may not have researched this issue prior to, or perhaps one of my colleagues can weigh in, which is to the extent that condo association, right, is contemplating making an exception to their declaration for the bylaw in order to comply with the Maine Human Rights Act. Does that require conforming to the procedures set forth in the Maine Condo Act?
I genuinely didn't look at it because that's not usually something we look at. We would disregard it. The Condo Act certainly doesn't preempt the Human Rights side, so we just get whether there was discrimination.
He's been doing this since June of 2023, correct?
At least since June of 2023, it might have been
Somewhat longer,
it might have
over
been
2 years. What's been what problems?
What problems are there?
Yeah, what specific problems are there? You have a list of complaints? Have you been sued by somebody falling down, getting into their wheelchair?
We have
What's
not,
the problem?
we have not been sued. To answer that question, we have been told the board may be sued by other residents for failing to adhere.
Hasn't happened in 2 years and 4 months.
It has not.
You originally had her request and you tabled it and rewrote the rule in order to cover her, in order to prohibit her business. Did you not? Isn't that what it says?
Well, that is what it says.
Is that not true?
That is not true.
Okay.
So the rule, as I read it to you, was how it existed all along.
Why'd you have to rewrite it? Why couldn't you deny it?
We rewrote it. We did deny it.
Okay.
The complainant requested an accommodation from the board.
Right.
We denied it. The complainant.
You didn't table it and rewrite the rule and then?
No, this was back in 2022.
Okay, all right, you've answered that. My last question is, how is it different from a therapist that has people coming from afar and parking and going into the building? And
It isn't, and we don't have any of those either.
says you do.
That's false.
Wait, there's one person presenting on behalf.
So we do not, the person that has been alleged to have a therapist coming over wrote a letter to the commission indicating they do all of their work via telehealth. They have no people coming to their house.
Did they make a request
Did they make a request for?
to have a business? Have an exception to the rule or whatever?
No, they did not, because they didn't have anybody coming. They're not in violation.
Nobody noticed.
They're not in violation of the rules.
Okay, thank you.
Yes, good morning.
Good morning.
Good afternoon.
Good, oh, sorry.
I just want to clarify a few things, and I appreciate you taking us through the rule, which I have up on my screen. This is a 68 unit condo
Association,
right? Yeah. Okay. And each condo, am I understanding correctly, they have their own driveways?
They have a shared driveway.
Shared driveway. So how many condos share driveway?
Two.
So, okay, so, and how many cars is there? I think usually there's some sort of allotment in terms of how many cars you can have. 2 cars each?
There are no rules about the number of cars you can have.
So whatever fits in the driveway.
Right.
This business about other businesses operating within your condo association, I just want to be clear about this. Now, the report says that there's an insurance adjuster, a therapist, and a provider of spices living within this association and providing services from their home. Your testimony today is that this is not happening? None of these people are providing services from their condos?
That is correct.
All right, so I guess, I want to preview for you sort of where I think this is going. You know, you're taking us through this rule. I mean, for example, you referenced somebody getting out of a wheelchair, right, and maybe falling in the common area on the way or whatever, and not providing a slip and fall risk. As somebody who has been litigating injury cases in this state, among many other types of cases for 22 years, I'd say it's pretty rare. And then you characterize some of your remarks with the statement, if we allow businesses to operate, our insurance may go up. If we allow businesses to operate, it changes the character of the association. Do allow businesses to operate. At least that's what this report said. We'll hear from the investigator. And then I'm I'm very concerned about the fact that I think that objectively speaking, and I'm just gonna tell you now, I think that a fact finder trial is gonna see it the way I see it. I think she is allowed to operate under this Rule 19. She's not bothering anybody. It's not like she's cutting hair out on the lawn, right? And listen, in my neighborhood, live in a nice neighborhood, we have a junkyard. I'm serious. We have a guy in this nice suburb, manicured lawns and all this, who's operating a junkyard right in the middle of this, right? That's completely different from this. And so I think a fact finder trial is gonna find that this business is permitted under your Rule 19 as it is. But then there's going to be testimony that you modified. I heard what you said, right? But you modified it, and it looks like the modification then allows these other businesses to operate, but not this poor one. So I understand you dispute that, and that's fine. But I gotta tell you, I think you guys have a situation here that needs to be dealt with in a manner different than the way it's been dealt with.
Thank you for that.
Any other commissioner questions for Mr. Durant? Okay, we've got 53 seconds when we come back to you. Attorney.
Hello.
Hello, thank you. I was just looking for your name. I appreciate that.
At the head of the table. Can you hear me?
I can, yep.
It might be to your right, but to my left is Meredith Scott, my colleague working with me on this matter. My client's here and her son. I won't mention her son's name. And in accordance with the rules, I'm going to try to respond only to the issues raised in the submission and argument made by the association today, and then obviously answer any questions or obviously asking you to affirm the recommendation by the investigator in this case. Let me start out by saying a couple things in response. Under the previous Rule 19, my client was operating her business. She asked for permission before she did it by speaking to the then property manager, who said she was in compliance. She also went to the town CEO, and then the town CEO said that there's nothing that prohibits you from my home occupation. And the rule that had been discussed allowed the very business. And then she took it a step further to be a good neighbor. She went to a meeting and asked to make sure it's okay. And at that point in time, she was basically told, in response to that, initially, she was asked, how many people come and provide services to your disabled son, which has no bearing whatsoever on her accommodation request at the time. And then they did change the rule to try to bootstrap that she can't operate her business, even though the rule previously allowed it. And they did allow businesses. You mentioned the ones that were in the report, but they allowed a dog walking business, a quilting business. There was a contractor with a bike rack. There was a stained glass, in addition to the ones before. And they retaliated against her for trying to do the right thing by changing the rule. Let me go to the issue. They seem to take the position that because we're a condo association, our Bible is our declaration, and our declaration preempts duties to accommodate folks in housing with respect to disability. And I'm glad to hear someone say that that's not true. But it's even worse than that. The board claims that the declaration bars all commercial activity. The declaration has not been changed. The Rule 19 was changed. They claim that the declaration prohibits all activities. We know that wasn't the case. And then why do they have Rule 19 in the first place if their own declaration didn't allow commercial activity? Because the declaration is silent on the definition of commercial activity. They contemplated somewhat commercial activity. That's why Rule 19 existed at the time. But then they amended Rule 19 to limit the business with more conditions, but they did that in retaliation of her request. In addition, at the fact finding and in our submissions, the board's own attorney advised the association that although the declaration seems to suggest that commercial activity is prohibited. It lacked the definition of commercial activity, and Rule 19 could permissively outline exceptions to this rule, and that the board could turn to zoning definitions to help interpret Rule 19 as describing what the ordinance describes as home occupation, and the board's own attorney confirmed that the two can coexist as commercial activities, which was never explicitly defined. But it was worse because the rule allowed it, she was doing it, she tried to jump through all the hoops, and then they asked a question about the services provided to her son, which had no bearing whatsoever, and then they changed the rule. They did more than that. They started assessing her penalties and fines and are foreclosing against her now. They did more than that. They reported her to her licensing board in the state of Maine. Now, I'm a general civil litigator, and I take all my cases seriously, but the board's not going to win here based, in my opinion, on the merits, on the law, on the duties to accommodate for housing. But if they proceed with this foreclosure action, they will have to evict my client. If they try to evict my client, I'm going to raise an accommodation as a defense. And that's a valid defense in that proceeding. And my client's been harassed. She's had her home sprayed with hair supplies. And all she's trying to do is earn a living. And take care of her son. When we talk about her son, the response was they even tried to offer to find her a place to go leave to work and bring her son to work. Let me tell you why that doesn't work. Couple reasons. She's not been there. It didn't work. Her son was also in an accident that aggravated his circumstance. We have no duty, and I don't think it's contested that he's disabled. He's severely disabled. We've referenced in our submissions that his primary care doctors said he needs stability, he needs his mother, who's his legal guardian, legally, and he needs to be in one place at one time. And it's clear. And then it really goes to the reasonableness of the accommodation request, which they flat out ignored. They haven't engaged the entire intervention process was, we'll give you 6 months to leave. That's not the interactive process. Her request is entirely reasonable given that the board previously allowed commercial activities under the previous rule in which we were asking for accommodation. The number of customers to the unit, we've agreed to limit to 3 or 4 per day. We agreed to limit 1 car per day. We agreed to only do it during certain hours of the day. Even before this all happened, you heard the respondent say 20 to 30 customers, that's 3 to 5 per week already. We have bent over backwards to try to find an accommodation that was reasonable, and it was flat out refused. And not only is it flat out refused, we're defending a foreclosure action for penalties that were incurred after they changed the rule. And we're defending a licensing complaint because they called. I'm a general civil litigator. This is the first time in 30 years I've been before the commission. I've done a lot of work in the general civil litigation world. And sometimes the law's on your side, sometimes the facts are on your side, and sometimes, rarely, both are on your side. They're both on our side here, and it's a compelling story. And it's frankly, we need a message to be sent to the respondent that because they're a condo that hides behind the declaration, that doesn't mean they can avoid their obligations to accommodate folks with disability to preserve the housing. I've said enough. I'll answer your questions.
Commissioner, questions for Attorney Bello? Okay, seeing none, you'll have a little over 2 minutes. We come back to you. Mr. Garrett, you have 53 seconds.
Thank you.
Well, there's some news developing here. This is the first time we hear that they would be willing to limit the number of customers per day. That was never put on the table. I want to address why we changed the rule. We changed the rule because COVID hit and people were calling the board at the time and saying, hey, can I work out of my house? The rule says no commercial activity. Well, everybody in the world was working out of their house. It was all telehealth meetings, telemeetings of all kinds. Once COVID ended, and because it was clear some people did not understand the rule, we clarified it to add to the existing criteria which she was not meeting to begin with. We did not make the rules stricter for her. We just clarified it. Thank you.
Questions for Mr. Harris? None. Thank you very much. Attorney Bello, you have 2 minutes and 9 seconds left. If there's anything else you'd like to add.
We made in defense to the foreclosure action, which is essentially if they prevail in eviction action, we made a recent lengthy reasonable accommodation request, which was flat out denied. And it specifically limited the number of customers. So the fact that he's saying there's news is just not true. And our accommodation request is attached to our Maine human rights complaint. It's not true. And they're asking for civil penalties in the thousands of dollars based on this revised rule, which we believe will show and a jury will show was done in retaliation against her. And now I'm left with fighting to preserve this home for Carolyn and stability for her severely disabled son. And if I have to go down that road, now I'm going to ask for attorney's fees and civil penalties. And I'm not in the guarantee business, but I'm more than willing to take this to a jury in Maine. It shouldn't have to be this way. We've made many reasonable requests and many reasonable accommodation requests, and they've been flat out ignored. And they even seem to suggest that we have autistic family members, but any doctor who would say that it's in the son's best interest to stay at home, well, that's exactly what his doctors have said.
Okay. Commissioner Douglas.
Just not a question, but a comment. I'm just going to add to Attorney Bello's rebuttal that the report says to alleviate concerns about her business altering the community's residential nature, complainant offered to limit her business to one appointment at a time, prohibit walk-ins, direct customers to park only in her driveway, provide clear visual instructions to locate her home, and restrict her hours of operation. So I'm just gonna put that up.
Any other questions for Attorney Bello? All right, seeing none, we've heard from the parties. Next, we'll hear from Investigator Morse.
Hello, my name is Angela Morse. I'm the investigator assigned to today's case. I don't have anything to add other than the fact that the limited appointments and all the adjustments that the complainant was willing to make to her hairstyling business was discussed in the recorded conference where I took detailed notes, as was the information regarding the individuals who were providing telehealth therapy sessions, the insurance adjuster, and the purveyor spaces. That's all in the recorded conference.
Thanks, Angela. Any commissioner questions for the investigator? Commissioner David?
I'm sorry, Angela, what did you just say about the insurance?
So those 3 individuals who are operating their businesses from their homes, that was all discussed in the conference. And for our housing cases, we take very detailed notes. You know, I don't know if the commissioners are provided with those notes or not, but you know, there's at least 3 or 4 pages of notes, and that was definitely discussed, as was the ways that the business could be limited. Yeah.
I've got it. You're saying that that's one of the other people that are operating in the building?
Yes.
Insurance just, no, I was still focused on whether or not they've been sued by, or their insurance rates have gone up in some way. Which there's no evidence of that. So,
Just to clarify, investigators' notes are confidential by statute, but the addendum that is attached to every housing report includes a summary of every conversation that we have with the parties.
Yes, that's what I was referring to. Sorry, the addendum.
Thanks, Angela. Any other commissioner questions for the investigator? Seeing none, I think we're ready for a motion. There is one proposed finding.
Yeah, I'll move that we find that there are reasonable grounds, we adopt the investigator's findings, that there are reasonable grounds to believe that the Oak Hill Condominiums Association discriminated against Ms. Thibault based on disability, and conciliation should be attempted.
Second. Seconded. Any discussion?
I just want to emphasize all of the manifest issues with this case, that you hear right now. And I'm sorry, I have to want to say this, but I don't find any of your justifications convincing for denying this woman the right to operate her haircutting business out of the condo. And you know, some of the most compelling things that I've heard today, there are 68 units. They share a driveway. There's no restriction on how many cars can use the driveway. So there are probably hundreds of cars coming in and out of here every day. Hundreds of people at least living in these condos. And we're talking about a few cars a day. The business operates inside. It's not like the junkyard in my neighborhood. So this business about Rule 19, and then you changing it. I find this case highly problematic. And, you know, I suggest you guys get a lawyer.
So,
Any
Well
further
said.
discussion?
yeah, these facts are incredibly problematic. In my sort of recent recollection, we haven't had sort of a factual presentation as problematic as this in a housing case. It's very clear to me on the basis of the investigators' report and the way the facts are coming to evidence here that it is you'd be well advised to resolve this in conciliation if it proceeds to court. You'll have significant challenges with the claim. So
Right, and let me just add, when you add in the fines and then you've levied and the foreclosure proceeding, I mean, you could really, I don't know what Attorney Bello was thinking, but you know, in terms of how he's going to proceed, but you could really inflame a jury with this kind of stuff. I've been there, I've seen it on both sides, so.
Yeah, and let's try not to offer advice to any of the parties. Any further discussion? All right, seeing none, the motion is to find reasonable grounds. If you vote yes, you are in favor. Commissioner David?
absolutely, yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
yes,
All right, findings are reasonable grounds. We will send a letter to the parties and council with the next steps.
Thank you.
All right, that concludes our hearing agenda for today. We'll take a break so you guys can get your lunch and then we'll go into executive session. Ed, you want to give us the? Hang on. There you go.
So the one MRSA, section 45(6)E, I move to go into executive session to consult our attorney regarding pending and from contemplated litigation and legal rights and duties of the commission.
Wait, second? Second. If you vote yes, you are in agreement. Sorry. Commissioner David,
Yes.
Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Thank you, sorry. All right, I'm also very hungry. Let's stop the video and we
It's not doing that.
So I need a motion not to litigate E 230206 or EA 230226. So moved. Any discussion? Commissioner David?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
I get a motion to adopt the agreements in MHRC versus T and MHRC versus Hassett and Maloney. So moved.
Second.
Any discussion? Commissioner David?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
And I need a motion to authorize the commission to take action up to and including litigation to enforce the Maine Human Rights Act regarding education.
So moved.
Second.
Moved and seconded. Any discussion? Seeing none. Commissioner David?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay. That ends the meeting. Thank you.